Made pleasure, Lordship. I have informed the other side. Can I pray for little accommodation in respect of item number 9, Miller?
8, 9, 9, 10.
Oh,
8, 9, and 10.
To be honest, I could not devote much time to this brief. That is some time.
When do you want?
Maybe in the January, Miller.
21st of January.
Oh,
21st.
After Bihu vacation.
21st of
the
January.
bench is also to be constituted.
Yes. Put down. Mr. K.N. Chaudhary, learned amicus.
And the amicus, Miller.
Appearing in item number 9, submits that he is not ready to argue the matter today and therefore seeks adjournment with a request to post this case again in the 3rd week of January 2025. A prayer for adjournment has not been opposed by the learned counsel for the appellants appearing in item numbers 8 and 10.
10.
In view of the above and on the request of learned counsel for all the sides, register to list this case again on 21st of January 2025.
Deep,
Fixed items.
May pleasure, Lordship. But this I mallet or bail mallet may be come up any day of next week.
Yes.
Lordship. Item number 68 in the hearing list, Lordship. That is
Item number?
68.
No hearing is taken.
No, Lordship. There's a matter bill and parties are willing to go for mediation. Can that be fixed for in the daily list so that we can go to the mediation? Lordship?
Next week.
Next.
Give a mention memo.
Mention.
Yes.
Oh, bless.
Okay.
Yes.
Daily list for orders, I can mark.
May it please your Lordship. Lordship, this case, Lordship has already admitted the appeal, Lordship. I am for IL, Lordship, 682, Lordship. Therefore, suspension of the sentence as well as for the bail, Lordship. Now, Lordship, this I'm for representing accused appellant, Lordship, Ramjan Ali, Yasin Ali, and Abdul Barek, alias Barek Ali, Lordship. They are in jail custody for last 15 months, almost 15 months, Lordship. In IL, Lordship, may I take Lordship order that is on page 70, Lordship. Relevant portion on page 72, Lordship.
Page 70?
2, Lordship.
Yes.
Since there was a liberty was granted, Lordship, to renew this prayer for bail, Lordship. So we filed this interlocutory application for suspension of the sentence as well as for bail, Lordship.
Paperwork has been prepared.
Yes, Lordship. Paper is prepared, Lordship. They have filed the objection to their bail, our bail, Lordship. That copy we have received, Lordship.
So there are eyewitnesses.
Lordship, eyewitnesses. There is the Lordship eyewitnesses, but the eyewitnesses, PW2 Lordship, she has been contradicted by other witnesses, Lordship. Because Lordship, what happened? PW2 said, she was inside the room with her husband, Lordship, and it was locked from outside, Lordship. Now other villagers has came and unlocked that room, Lordship. If other villager came, then unlock the room, Lordship. Where is the question of eyewitness, Lordship? They are inside the room, Lordship. They have not seen the incident, Lordship. PW7 say they are the independent witness lordship. PW7, may I take lordship to PW7 lordship? Page 26 lordship.
No, where is the paper book? The court has recorded a finding that PW's 2 and 3 eyewitnesses, their versions have been corroborated.
Yes, lordship.
So that finding is wrong.
No, I'm not on that
Then
lordship.
there is finding corroborated.
Because lordship, that things lordship, probably this was, that time paper book was not before this court lordship.
Just see PW2.
PW7, that is on page 26.
No, eyewitness is PW.
PW2 lordship.
Yes.
That is on page 13 lordship.
Hmm.
May I read lordship, the chief portion? On the date of incident at the relevant point of time at about 2:30 a.m., I heard cries from the room of my son and daughter-in-law. Hearing the aforesaid cries, I attempted to came out from my room, but I found the room was closed from outside. Then my husband used force. Then the door was open. After coming out of the room, we found that my son, Rafiqul, was lying in the courtyard of the house, and also found that accused person, along with Barek and Umar Ali, were assaulting elder brother of my husband, whose name is Junab Ali. This Barek Ali and Lordship Umar Ali, she said she saw that two person assaulted her son, but she did not state it before it to the investigation officer, lordship. Now, lordship, kindly come to the cross part, lordship.
1 minute, 1 minute.
I6, look to. I took. I.
Yes.
Nine.
What do you want to show in the cross?
And cross lordship, may I read, lordship?
Yes, yes.
In
please
my
come to the main point. Please come to the point.
Yes,
What do you want
Lordship.
to show?
She said, lordship, she has been, the door has been broken by her husband, lordship. But her husband also inside the room.
No, she didn't say that.
Yes,
She said the husband opened the door by using force.
open the door. That means the husband is inside the room, lordship.
Yes.
Inside the room. Now, lordship, kindly go on to the PW7, lordship. Page 26, lordship.
Hmm.
It's also night.
See, he is inside the room.
Hmm. What is the name of husband of the PW2?
Lordship, Jalil, lordship, Abdul Jalil, lordship. He is PW3, lordship.
So what do you want to show from PW7?
Cross part, lordship.
Hmm.
Muslim Ali Hussein Jalil and Sadullah also came to the place of occurrence, hearing hue and cried at the place of occurrence. One of the room of the place of the occurrence is closed from outside with a sickle chain, and another room was closed from outside with a rope. Some villagers opened the same. The bolted room, which was bolted from outside with a rope, belonged to Rafiqul, and other room belonged to Jalil. That is Abdul Jalil Lordship, PW3. Along with Rafiqul, his wife staying in the said room, and Jalil and his wife Rafia stay in the other room, bolted room. After 10 minutes of the incident, I have seen Jonab Ali was lying on the ground behind the kitchen. At that time, Jonab Ali was unable to speak and he was unconscious. About 50 to 60 people rushed to the place of occurrence after hearing hue and cry. At that time, family member of Jonab Ali did not utter the name of the miscreant. Nobody was named in the FIR. It is not mentioned in the FIR who has assaulted whom and who has entered that.
There is an injured.
Yes,
witness,
Lordship,
Rafiqul.
PW4, Lordship.
Let us,
Rafiqul, Lordship. Page 19, Lordship.
yes.
May I take you, Lordship, the cross portion, Lordship, that is on page 20, Lordship.
Let us, just a minute, let us read the in chief. Yes, what do you want to show in the cross?
Lordship, kindly, page 20, Lordship. 1, 2, 3, 4, 5. 11 line from bottom, Lordship.
Yes.
It started with 9/7/2005, Lordship.
Mm.
I made statement before police that someone covering his face with a piece of white cloth armed with dagger. I had shouted when the accused person assaulted me mercilessly. Accused assaulted me with the wooden handle of the dagger, Lordship. Now, he has not seen, Lordship, who has assaulted him, Lordship. That person covered with cloth, Lordship, in the face, Lordship.
No, but the main case is not about assaulting him, about the death of Jonab Ali.
Death of Jonavali, Lordship, it is not proved that these are the petition appellant, Lordship, who has entered their room, Lordship. That has to be established first, Lordship, whether they are not they are there or not. Lordship, kindly come to the page 24. That is PW6 cross part, Lordship.
Yes. Yes.
Prospered Lordship.
Yes, please.
May I read? Prospect, when Ajar was lost, police asked if anyone see the incident to that. We answered to the police that nobody seen the incident. At that time, informant Shah Jamal, other witnesses are present, and they also told that they did not witness the incident. Lordship, nobody has seen that incident. I accompanied informant at the time of lodging of the affair. In the Azhar, name of the accused person not mentioned. I know the content of the Azhar. I know the witness Rafiqul. Witness Rafiqul married a girl belongs to different religion after eloping her. At that time of conversation of her conversion of her religion, panic situation took place in the said village and quarrel took place with Rafiqul for the reason of conversion of a religion of the said girl, and after few days, Jonab Ali was murdered.
So here, how many applicants in IA?
In this case, Lordship, 382, Lordship, three appellant, and their case, Lordship, there is one.
Quran Ali is separate.
Separately filed.
Paper book is ready. We'll give you a hearing in second week of March.
Lordship, can it be before, in the month of January, Lordship?
No, it cannot be.
Lordship, January, because we are not on bail, Lordship, that much, Lordship.
March first week I can give you if you want. Otherwise, we'll pass an order, effective order, and whenever it comes, it comes.
Because Lordship has heard this matter earlier also, Lordship, that's why we are lucky to get this bench again, Lordship.
I understand you're referring to my Lord Justice Kalita. He will be there in this bench, whether I'm not there or not.
Yes. But we expect this bench also, Lordship.
Not a good case for bail. But we can give you early hearing.
May I, Lordship, January, Lordship.
3rd January.
Obliged, Lordship. Obliged.
You are always unreasonable. Huh? It is earth-shattering. Yes.
In the facts of the case.
Are you also in a hurry?
Lordship?
Are you also in a hurry?
No, Lordship, whenever Lordship takes it up. Otherwise, the point that he has raised, he had shown that Rafiqul had not actually seen. But little after what he had placed the sentence, he said that there was a torchlight and I could see the accused persons. And he was an injured witness. He was taken to the doctor immediately after the occurrence.
We have to see whether he can be treated as res geste witness. Both of them.
That is also there.
Because it appears they have not seen the incident.
Now, 1 and 2, the husband and wife, they came little later. But Rafiqul, in his examination in chief, he said all these persons' name, taking their person's name also. And in the cross, he said, little after what he had placed, that I had seen them assaulting. And there is a reason also. Motive is also there. 1 and 2, although they came little there after the occurrence, they had seen some part of the assault. And Rafiqul was taken to the doctor, so informant was not aware when he lodged the Ejahar. Those things has to be seen.
But Rafiqul, Lordship, in chief, Rafiqul said the person who has come, their Lordship, they call the Rafiqul come out, not the Jonab Ali, Lordship.
No, Jonab Ali went when he heard the hue and cry.
There is no motto to kill this Jonab, Lordship.
Yes,
Yes.
They
They are searching Rafiqul, Lordship. There is a Lordship dispute regarding that marrying of a Hindi girl. That is also there. That was raised in the evidence also, Lordship.
All right, you get a hearing on 11th of February, correct? 11th February 2025 as a fixed item. So you want the order to be passed in the IA?
Yes, Lordship.
Order to be passed. All right. You want to say something? Huh?
We have no question.
All right, take down.
Leave your loss.
Heard Mr. B. Chaudhary, learned counsel for the applicants in IA criminal number 682 of 2024, arising out of criminal appeal number 268 of 2023. Also heard Mr. A.M. Ahmed, learned counsel for the applicant in IA criminal 445 oblique 2024, arising out of the same appeal. Ms. S. Jahan, learned APP Assam, has appeared for the state. The three applicants in IA criminal 682 and the sole applicant in IA criminal 445 of 2024 were convicted under section 302 stroke 34 of the IPC for committing the murder of, this is 34, is it?
34.
34, no.
Committing the murder of Jonah Wali, inter alia, convicted inter alia under section so and so for committing the murder of Jonah Wali and sentenced to suffer life imprisonment for the offense under section 302 of the IPC. Most other jail sentences were also awarded to the applicants under sections 458 stroke 323 stroke 34 of the IPC. Full stop. By the judgment in order dated 36/2023, passed by the learned Additional Sessions Judge Bilasipara, Assam, in Sessions Case number 211 oblique 2011. The four applicants, so since then they are in jail. Full stop. The state has filed objection opposing the prayer for bail made by the applicants. Full stop. After going through the records, we find that the injured eyewitness in this case, namely PW7, has implicated the accused persons. PW4, is it?
PW4,
PW4 has implicated the accused persons. Full stop. Moreover, PWs 2 and 3, who have been examined as eyewitness to the occurrence, in all probability, the eyewitness to the occurrence have also deposed in similar lines. Full stop. Mr. Chaudhary submits that PWs 2 and 3 are not eyewitness to the occurrence, and there is material contradiction in the testimony of PW4. Full stop. After a careful analysis of the materials available on record, we are of the view that appreciating the contention of the applicant's counsel would require detailed hearing of the appeal. Full stop. However, in view of the evidence of PWs 2, 3, and 4, we are of the view that this is not a fit case for granting bail to the applicants. As such, the prayer for bail made by the four applicants stand rejected. However, considering the request made by the applicant's counsel seeking early hearing of the pending appeal, and in view of the fact that paper book has already been prepared in the appeal, we are inclined to grant the said prayer. Full stop. Order would be passed accordingly in the main appeal. With the above observations, both the IAs stand disqualified. Main appeal, both are appearing in the appeal.
Yes.
Heard Mr. So and so for the appellants. Ms. S. Jahan, learned APP Assam, has appeared for the state. In view of the order dated so and so, Hazir order passed in IS so and so, the criminal appeal is directed to be listed for hearing on 11/2/2025. 11/2/2025.
Oblige.
And then next time.
For hearing 2 and 3.
May I please, your lordship? I am for respondent, your lordship. Mr. Jadalam is having some difficulties today, your lordship. Kindly matter be fixed on 16th of this month, your lordship.
Their alarm is for whom?
For the respondent, your lordship. Item
You
number,
should have informed me yesterday, you know, it's. You are taking the permission. Well, we are in custody for last two occasion also, they have taken time.
You have not informed in advance.
No, madam.
yes, your lordship.
We have not been informed in advance, madam.
Your lordship,
I am in custody for last 5 years, 8 months. And this is a small point involved, my lord. I am not going for the clear acquittal. It's a case of a single injury, my lord. Single blow incident, only 2 or 3 witnesses, 1 eyewitnesses, 1 doctor, my lord.
You want conversion.
I want just in conversion, my lord.
Then you can wait till 17th. Tuesday,
17.
but no adjournment. 17th of this month, or maybe 16th.
on 16, your lordship.
This week is possible, my lord.
This week, not possible, your lordship, on
16th, you are not available.
My lord, the next one, the possible, my lord, because I am in custody for last. And I have
That's right, but
prepared,
this
my lord,
bench
the-
is not available for 2 days this week.
my lord, then thereafter, my lord, on Friday, whatever.
16 is that.
17. On 17, my lord.
17.
Hmm?
No, you both of you agree and there will be no adjournment.
Last 2 occasions they have taken time also, I don't know. They are not in the party in the first one.
I'm the party in the second.
He is not
appeal
in
against
the acquittal.
In the appeal against acquittal, item number 3, your lordship.
He is not
and-
in party in
and,
this first one, my lord.
comment. On 17, your lord, 17, your lordship, okay.
No, just a minute, just a minute. You
first
are in
one-
which case?
Item
In the
number,
3,
uh,
he is not even party in this item number 2.
I'm
What has
reading-
item
I'm-
3 got to do with item 2?
They are related, connected out of the same judgment, my lord.
Yes, your lord.
Appeal against acquittal, my
Acquittal.
lord, altogether 4% has been, they have faced trial, 3% has been acquitted. And the 1 has been convicted, my lord. Against 3, my lord, they have preferred an appeal against 2, my lord.
Item number 3, your lord.
In appeal, that is
These
item
matters are
number,
tagged together.
Yes, your
this
lord.
has been tagged
2 and
together.
3, your lord.
2 had been 2.
17th,
17, your lord.
no adjournment on that day.
Yes, your lord.
Heard Mr. M. Borel and Senior Counsel appearing for the appellant in item 2. Also had Miss S. Shah.
S.
Who is done and APP Assam representing the state. Miss S. Nazneen, Nanet Counsel for the appellant in item 3. 6, adjournment in this case on the ground that our senior, Mr. Z. Alam, is unavailable today. First up, the prayer is opposed on the ground that several adjournments have already been availed in item 3, as a result of which the appellant in item 2 is languishing in the jail. Mr. Bora further submitted that no prior information of the prayer for adjournment has also been furnished to him. Having regard to the facts and circumstances of the case as well as the urgency expressed in the matter, we direct the registry to list both these appeals for hearing on 17/12/2024 as fixed items. It is made clear that no prayer for adjournment will be entertained on the next date fixed.
On behalf of the respondent.
Either side.
But in my case, then I'll be in difficulty, my lord. All the time they are taking the time, my lord.
You won't take time, obviously.
My lord, in case, my lord, there is
Then
some
let's-
difficulty.
Oblige, your lord.
Oblige, ma'am.
Four, five, six.
My senior is on legs, lordship. He will come, lordship.
Let's, I can start.
Who is the
Oh,
senior?
Jessica,
Essika, lordship.
we can start. Senior stated. Senior stated, we can start. Lordship.
All right. You will be able to finish today?
Yes. In this case, Lordship, petitioner was arrested on 16/5/2016, Lordship. And since
So
then.
first of all,
six-
why so many appeals? Same transaction.
Out of same judgment, Lordship, 3 appeals preferred by the appellants because 4 appellants were there, Lordship. At the time of filing, Lordship. In 288, Lordship, Muhammad Mujibur Rahman represented by Senior Counsel HRS Chaudhary. Then other 2 Lordship in 362 appellants Ram Milan and Abdul Kalam. Then Lordship 393 subsequently came Saurabh Khan, Lordship. So out of same judgment, Lordship. The appellants were arrested on 6/5/2016. Today is about 8 years, 7 months, 4 days, Lordship. And the sentence, conviction and sentence is for 20 years.
Commercial quantity.
Commercial quantity. So in this case, Lordship,
2019 appeal.
April 19, but they were arrested on in the year 2016, but they did not get bail during the trial, Lordship. And thereafter, Lordship, during the appeal also they approached before this honorable court, but honorable court fixed for hearing, Lordship. In this case, Lordship, one mandatory provisions we have filed additional grounds regarding mandatory provision,
Where is the
Lordship.
paper book?
Would you? Would you? Would you?
Yes.
Corrected. Madam, in this case, we filed an additional affidavit for grounds. We have taken the grounds, Lordship, regarding non-compliance of section 52A. And Lordship, in this case, Honorable Apex Court right now on hearing completed to that regards. To our information, Lordship, and to that regards, Lordship, judgments CAB till today not passed regarding non-compliance of 52A.
Yes, sir. Which case is that? Some matter pending in the Supreme Court for delivery of judgment on this.
Delivery of judgment regarding 52A
Already hearing concluded and judgment is reserved.
reserved. So that is why,
Then I
but
think
we will not on right now because they are inside the jail. Apart from that, Lordship can go through other part also.
So you will not argue on 52A.
We'll argue, Lordship, because already decided by the apex court. After that, Lordship, when they have raised a point, whether it is applicable at the time of disposal or at the time of search and seizure. That part is there. We'll argue on that point also.
You argue, but will not deliver the judgment till
But Lordship,
Supreme
they-
Court comes. Judgment comes.
Lordship,
And if we reserve it, then you will not get a chance to argue if the judgment goes in your favor. That's the risk you have. You can take that risk if you want. Because once we are informed that this on the same point.
yes,
matter has been
that is
heard-
why I raised the point, Lordship, because already one issue raised by the on the same contention. That already my Lordship has heard on that point earlier occasion. At that point, that was not came out, Lordship. And
When was the judgment reserved? When?
it is reserved in the last Lordship, I think Next,
November.
last week, like. USA, your lordship,
3 weeks ago.
28 November, lordship.
See, the technical problem is even they will raise this plea.
Yeah, obviously, that is why I raised the point, lordship, because
And
we,
once we are informed that the Supreme Court has heard and judgment, if it was pending petition, then we'll proceed.
yes, yes,
But now it has been heard and judgment is reserved.
yes, lordship,
So we will not deliver a judgment.
yes,
If you raise this point, if you give up this point, then it's fine, which you will not. Why should you give up that point?
yes, yes, of course.
We'll not deliver the judgment. We'll keep it reserved. But for some reason, if the Supreme Court judgment goes in your favor, you don't get a chance to address.
Yes, yes, lordship.
That is a risk which is involved.
If lordship, we would not have raised that point, they would have raised. That is why at the initial stage, I raised the things, lordship, at that point.
141, 142.
Yes, 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 lordship.
Article 141, 142 will come into play.
And-
They are in custody for more than 9 years.
9 years.
Our-
About 9, about
Going
9.
into section 52, lordship, if lordship, that minimum sentence of 10 years.
No,
is
we
imposed,
understand. What is the way out? Tell us what is to be done.
that is why.
If the matter is pending, we will not deliver the judgment before the Supreme Court.
Conviction, retaining the conviction, lordship, sentence part, if it is reduced to 10 years, lordship. that
Then they
for-
will get the benefit.
Yes. Without going into that 52A, if conviction is maintained and period that minimum sentence of 10 years is imposed, is subject to what my learned friend says. If that can be done, lordship.
We can talk with the Lane PP also yesterday night,
In
lordship.
that case also,
In that
that
regard,
matter will be disposed of.
uh,
Minimum sentence.
Because-
They have no criminal antecedent or other thing is there,
Yes.
considering those mitigating circumstances.
So this is permissible under the law.
yes, yes,
Minimum
we have,
sentence is 10.
we have a judgment, lordship, 2012 judgment. If no criminal antecedents and their records is good in the jail also. And lordship, this is the first offense, lordship, that on that ground, lordship, honorable apex court had reduced the sentence, lordship, from 15 years to 10 years.
But
If Larned PV consent to that regard, let him come, lordship, we will wait for that,
all right, let him come.
let him come. Then if it will reduce to 10 years, then they can get the benefit, already about 9 years, lordship.
Let him come.
Honorable lordship.
You talk to him and
Yesterday night we talked over telephone, lordship, regarding this.
we'll record his.
Yes, yes,
confession.
of course, lordship. Honorable lordship. Item 7.
Yes, Mr. Kyle. We're in item 4, 5 and 6.
Yes, Lordship.
It seems on the rigors of section 52A, the Honorable Supreme Court has heard a matter and judgment is reserved.
Yes, Lordship, that
So
judgment is-
what she's saying, or rather they are saying, is that without disturbing the conviction, if the court can reduce the sentence, then they will be satisfied with that. What is your,
Lordship, with regard to that, Lordship, I have to address your Lordship on this point. Minimum
to-
sentence is 10 years.
Hmm.
Here they are completed for 20 years.
Hmm.
And up to your Lordships to consider all these things. Because I cannot make any submission contrary to. Because 52, there is a law held in Mohalla, thereafter 2 judgments are there. But recently on 18th of November, Honorable Supreme Court heard the matter on 52, whether sample is to be collected at the spot or before the magistrate. That judgment discussion is with me, but judgment is yet to be pronounced. Lords.
what is the bench? Which is the bench?
Justice,
Justice Bella M. Trivedi and
this is the discussion reported in
Only-
library. Lords.
Huh?
And yesterday I also check out.
Satish Chandra. Justice Satish Chandra Sharma and Bella, Justice Bella M. Trivedi. Lordship.
So then you argue on, but the problem is then you have to argue on both.
Both.
It can't be a consent order.
Lordship.
You have to satisfy us that. Now,
get it.
if you argue on 52A, then we'll not pronounce the judgment. Otherwise, you have to give up 52A, which is a risky thing.
Yes.
What do you want to do? You decide. I think if you spend 9 years plus, you
Yes.
better wait for another month or so. Because if you get the benefit, it becomes very easy. for you.
Lordship,
Yes,
because that's the thing, Lordship.
Otherwise, we
Because
don't have any
already,
problem.
Lordship, already in Mohanlal, already decided in the year 2016. Thereafter, all the cases depends upon that acquittal, all the cases, all the appealants are acquitted, Lordship. Not by the, not only by the lower courts, but in the Supreme Court also, Honorable Supreme Court also, we got lots of judgment, Lordship.
Union of India versus Mohanlal.
Yes,
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 Lord. This is the
2016
basic-
judgment. This is the basic judgment, Lordship.
Adjournment took place during the appeal. It took place.
Let us have it on 20th February. By that time, the judgment should be out.
Lots.
Or
Can
you
it
want
be-
it earlier?
Can it be little bit earlier than,
Just suggest a date.
Lordship, 21? Huh? No, yet no.
23rd.
23rd January, Lordship.
23rd January. All right, you see, we don't have any option but to
Lots.
take this course because we will not give our opinion on
Yes,
applicability
yes,
of
of course.
52A.
That is why we raised that point first, Lordship.
And if
Or
you-
Lordship can pass this order if convert this from 10 years, 20 years to 10 years.
That's what we are asking you. Then you have to give up your argument on 52A.
কি করবে?
And then also you have to convince the court. You may or may not succeed. So it's a dicey.
Let's wait for.
All right, had Miss S. K. Nargis, the counsel for the appellant in item 4. Also, item 4 and 6 also had Mr. Yamen Lanet counsel appearing for the appellant in item 5. Mr. S.C. Kyle Lanet SC NCB is present on behalf of the respondent in his appeals. At the commencement of hearing, Ms. Nargis, in her usual fairness, has submitted that one of the key points raised in these appeals is pertaining to the effect of non-compliance of section 52A of the NDPS Act. Full stop. However, the Honorable Supreme Court has recently heard an appeal involving the same point and the judgment has been reserved. Full stop. The learned counsel for the appellant submits that since her client is in jail for nearly 10 years now, hence the appeal can be heard on the question of reduction of sentence, if not on other counts. Full stop. However, Mr. S.C. Kyle has responded by saying that the appellants will have to argue the matter on merits, even for reduction of sentence, as he is unable to make any concession in that regard at this point of time. First of, Mr. Ahmed, learned counsel for the appellant in item 5, has also expressed similar opinion. Such being the position and considering the fact that the Honorable Supreme Court is in session of a matter wherein the same point is involved, we are unable to proceed with the final hearing of these appeals before the judgment is delivered by the Supreme Court on the aforesaid point. Situated thus and on the request of learned counsel for both the sides, let these appeals be listed again on 23rd of January 2025. In the meantime, if the judgment of the Honorable Supreme Court becomes available, this same be brought on record.
Lots. Much.
These are very bad technical situations, but then what to do? We have a mandate of Article 141, 142. It may be viewed as
Lots.
uh,
And probation offender set is also not applicable in the case of NDPS. Also. That is the difficulty.
if we deliver a judgment when the matter is pending, this may not go down well.
Lots.
Much.
May it please your lordship. Here lordship, the conviction is under section 302. Before making my lordship submissions or the arguments on which I am seeking the acquittal lordship, just may I read the FIR first lordship. Page 4 is the FIR lordship. Acquitted. Motley হয়তো পলাই দিলে।
Yes, please.
Lordship. Humble submission is that around 7 p.m. on 5/8/2005, while my younger brother Gyasuddin was uprooting paddy sapling on the bank of his pond, the below mentioned accused persons, armed with dao, spear, etc., attacked him all of a sudden and killed him on the spot by stabbing him with daos, spears, etc. Hearing his scream, when his wife Muhammad Atia Begum rushed to the spot, they hacked her too with dao, thereby causing grievous injury to her person. So Asia Begum is PW2. Now here your lordship will find 6 persons are named in the FIR. First, that Abdul Motleb, he was there till recording of the deposition. His in the judgment it is written that in 313, after 313 he absconded, but I will take your lordship to the 313. There is no signature of Abdul Motleb in 313. And second, your lordship, Jiabur Rahman, he is acquitted. All are acquitted except the present appellant, that is accused number 6. Abdul Motleb and Mosan Mia are convicted. Others are acquitted. And it is said that Abdul Motleb absconded after 313. But what I find from the records, lordship, that in 313 his statement is not there. And even 313
Motleb, you say is absconding.
absconding. Till date, lordship, he is absconding.
So he has been subjected to trial.
He was there till recording of the depositions, lordship, of witnesses. After recording his statements of deposition, lordship, from 313 stage he absconded. And even if your lordship kindly turns to that
No,
313.
just a minute. So he absconded, so therefore this accused did not get a chance to adduce evidence in defense. So he did not get or
Lordship.
was not.
that he waived that part. Abdul Muttalib waived. Because he absconded, so judgments are there. If we have accused absconded after recording of evidences, so that will imply that he waived that part.
And he is still absconding.
And still absconding. So Lordship may kindly now turn to page 86. This is the 313 statement of Abdul Muttalib. Here, Lordship will not find the signatures of the presiding officer or the signature of the accused.
Page 86.
86. And all the questions and answers are, Lordship, typed and copy and paste, Lordship. Because Lordship may kindly see page 61 onwards, question number 9. That only question number.
Abdul Muttalib, you are not representing him.
So I am not representing him, but I am just showing before your Lordship how 313 is recorded. Because that way that affects the petitioner also, because he did not get any chance to give his explanation.
So you show the 313 of the petitioner.
Lordship, before that, Lordship, just I am showing how that is recorded, Lordship. That page 61 starts off, Lordship, Mosaddar Ali, Masad Mia. Question number 9 of all the accused, just I am showing one question, Lordship. Question number 9, page 63, Lordship will find. Answer, Lordship may kindly see. I am only referring to the answer part. Mosan Mia, he is a male person, Lordship. Question answer. I have been falsely implicated. I am innocent. I was at home. I gave birth to a child 4 days before the occurrence and I was on bed. That again your Lordship will find the another accused, Noor Ahmed.
How Mosan Mia is a male?
Male. This is copy paste, Lordship, 313 statements. Again, Lordship, I am taking to another accused, page 66, Noor Ahmed. Again, that question number 9. Page 68 is the relevant question, Lordship, page 68. Question number 9, left hand side, your Lordship will also find his signature, Noor Ahmed, male person. Then again answer, I have been falsely implicated. I am innocent. I was at home. I gave birth to a child 4 days before the occurrence and I was on bail. Then again, your Lordship will find 71 of Jiabur Rahman, page 71. Jiabur Rahman. Again, same thing, that question number 7 appears at page 73. Answer is same. Question number 9. Original signature. Yes. And then page 76 is Rehana Begum. Our question, that question number 9, this is also same, page 78. And then Lordship, page 81, Patarun Nessa, she is female. Again, that same question, answer, Lordship.
All right, so this is only in respect of question number 9?
9.
Huh?
And everything is same, Lordship. Everything
What
is
question number 9? PW9.
PW9, that Lordship, other questions are also same. Just why I am saying that while recording 313, Lordship, that questions were, answers were also pasted from the other answer of all the accused. Question and answers were copy paste, Lordship.
Yes.
And that the accused of Abdul Muttalib, your Lordship will find page 86. Although in the judgment I have found that after 313 it is said that.
So are you saying that 313 was exercise was never done?
It was not properly recorded. In papers it is there.
No, listen.
Lordship.
If you admit that it was done,
Lordship.
but not properly done,
Lordship.
then the course of action will be something else.
Lordship.
You said that it was never done.
Lordship.
Then the course will be something else. Which of the two is your stand?
My stand is that, Lordship, it was not properly done in respect of the other accused person, but regarding Abdul Muttalib, it was never done. Abdul Muttalib, your Lordship will find page 86. In that case, Lordship, his case should have been, Lordship, split up.
Now, Abdul Muttalib, you are not appearing.
I am not
We are
appearing.
not disturbing the conviction of Abdul
Lordship,
Muttalib.
Lordship.
So why are you referring to Abdul Muttalib? You can only argue for Masan Mia.
Yes, I am arguing only for motion, yeah, but I am just.
Was it done in his case or not? Was 313 statement of Masan Mia recorded or not?
Recorded.
So it, according to it was not properly recorded.
Properly recorded.
All right. So there you have to show the prejudice.
Lordship.
You have to show what was the version and how you have put it before the witnesses during cross-examination. Otherwise, we'll not go into it. This will be
That I will place before your lordship. That I will place. And second, my ground is that from the FIR, your lordship is saying that allegation is against all the 6 persons. In deposition also, your lordship will find that allegation is against all the persons. But the learned trial court lordship only convicted the accused number 1 and the present appellant, while acquitted the others by disbelieving the evidence of other witnesses. And my submission is that, lordship, when there is, lordship, similar allegation or similar accusation, the one person cannot be acquitted and while the other cannot be convicted, lordship, at the same time. That in support of that, I will submit judgment of honorable apex court. So now, if I may take your lordship to PW1.
So you are saying that supposing one person has committed an offense
Lordship.
and 5 others are implicated in the incident,
Lordship.
at the end of the trial, the court finds that these 5 were not involved
Lordship.
and acquits them.
Lordship.
The court is also bound to acquit
No,
the
lordship.
first
What
one,
I am
even if he is involved.
No, what I am saying is that, lordship, if accusations are similar,
Hmm.
for example, lordship, if says witnesses says that A assaulted with dao, B assaulted with lathi, then one cannot be acquitted and other cannot be convicted. If both allegations are there, I'm only on that point.
Let
Lordship.
us, I am aware there is a judgment which says
Lordship.
that when
Lordship.
the evidence is one and the same,
Same that I
it
will
cannot
place.
be interpreted differently for different
Lordship,
people.
lordship, that is my whole case,
Yes.
lordship,
That judgment is there,
lordship.
but there is a fine print to that also,
Lordship.
because it can happen that in a group, one is actually guilty, so out of anxiety, prosecution.
Yes, that
accuses
may, that
everyone. So if the
But
grade
here-
can be, but if cannot be segregated, then of
Lordship.
course,
Yes, that is my only case. If it can be segregated, I have no case. But if your lordship finds that the accusations are similar, then lordship, I
the
have a case.
accusation can be similar, if the evidence can be segregated.
Yes,
Then,
Yes.
yes.
if I, lordship, may read the evidence of PW1, he is the informant, lordship, and brother of the deceased. And he said, lordship, he did not see the incident of assault, lordship, but still I am reading his evidence, lordship. I know the page 12 is the evidence. I know the accused persons. They live adjacent to my house. Accused Rehana is my niece. Accused Jiabur is my nephew. And other accused persons are my relatives. Deceased Gyasuddin was my younger brother. He was a married man and had 7 children. They all live with me. During the occurrence, Gyasuddin was living separately in the same compound. The occurrence took place about 3-4 years ago. The occurrence took place right after the evening namaz, Mohammedan prayer of or worship to God. At that time, I was in the market. I was coming home on a bicycle. It was a temperate weather. At that time, about 5-6 people of the village were coming after me. They told me that there was quarrel between my brother Gyasuddin and my sister Patarun Nessa, and I should go there early. They took me with them. Going there, I saw people holding my younger brother Gyasuddin in injured condition. Going there, I saw Gyasuddin in injured condition. I saw cut mark on his back caused by dao and dagger. A lenja, a kind of sharp weapon, was pierced through his right armpit, which was visible on the other side. The lenja was still there. I saw other injury on his forehead caused with spade. I found the VDP secretary there. VDP secretary is PW3. I do not know his name. On being asked, he replied that he was on the road. Hearing the scream of Gyasuddin, he went there and saw accused Motleb dealing blow with lenja. Along with, it is illegible. I also tried to read out from the original, also I could not. I accused Nur Muhammad and Jiabur also dealt blow with a lenja on the body of Gyasuddin and stabbed him with dagger. At that time, Gyasuddin's wife, Asiya Begum, came and went to rescue her husband. She jumped into the pond. Then accused Nur Muhammad and Jiabur dealt dagger blow on the right hand of Asia. She got injury on her hand. Points to accused Ali. The said accused persons hit on Ghiyasuddin's forehead with a spade and cut his nose. Then accused Patarul said, "Kill him, Ghiyasuddin. If he remained alive, he would kill you all." Ghias' wife becomes senseless. BDP Secretary and President Yusuf Loskur informed the Doboka PS over phone, and police came there about half an hour after my arrival. Going there, I found Ghias dead and Asia in unconscious state. I did not see any incident of assault. Police arranged treatment for Asia Begum at Doboka Hospital. From there, Asia was sent to Nagaon Hospital. Other people accompanied her. 1 hour after the shifting of Asia, police took the dead body of Ghias to the police station. When police held inquest on the body, I was present there. Exhibit 1 is the inquest report, signature. After that, police got the postmortem examination of the dead body done at Nagaon Civil Hospital. I also went along with them to Nagaon Civil. Later on, the dead body was buried as per religious norm. On the following day of the incident, I lodged an Azahar with Doboka police station. I did not remember who wrote the Azahar for me. I do not know how to read and write. I can give my signature only. Exhibit 2 is the Azahar lodged by me. The accused persons fled after committing the murder. Later, police came and carried out an investigation and examined us. One day before the occurrence, a quarrel took place between Ghiyasuddin and my sister Patarul over illegible. The accused persons killed my brother for that reason. There was no enmity between them. There was mutual harmony between them till the occurrence took place. We brought Asia to our home from the hospital on the same day. On the day of occurrence, I did not talk with her. Cross. On the day of occurrence, I saw police. I had no conversation with the police. I did not before police. I did not tell to the police. On the day of occurrence, I did not inform police the things which were mentioned in the Azahar. When police came, about 1,000, 2,000 people gathered there. Some people went to the police station. I also went there. I stayed in the police station for about 2.5 hours. I had no conversation with the police on the day of occurrence. Police did not ask me to. Next day, around 12 or 1 p.m., I lodged an Azahar with the police station. At that time, Nokaruddin and Riazuddin went with me. I gave the Azahar to the Daroga. I got the Azahar written at a distance of 1 kilometer from the police station. When the Azahar was written, Riazuddin and Nokar were there with me. They also, 11, Nokar is my uncle and Riazuddin is my brother. I told the names of the accused persons. It is not a fact that today I have adduced false evidence against the accused persons in the court. That no such incident was occurred. That I met police on the day of occurrence. I did not tell this in the court or write in the Azahar. And on the following day, I lodged this Azahar implicating the accused persons on false ground. The reason for delay in lodging the Azahar is not mentioned in the Azahar. My statement given before police was same as my evidence given today. It is not a fact that I came home on bicycle from after the evening namaz, that 5-6 villagers were following me, that they told me that there was quarrel between Ghias and Fatarul, and that I did not tell this before police. It is not a fact that I did not tell before police that they showed me the dead body of Ghias at the seatbed, that I saw cut injury caused with dao and dagger on the back of Ghias, that a lenza was pierced through his right armpit, which was visible on the other side, that I saw cut injury caused by spade on his forehead, and that I saw on his head. It is not a fact that I did not tell police before that. I came to know about the incident from the BDP Secretary Ataur and that from there I went to illegible. It is not a fact that I did not tell police before the things that I have heard from, that hearing the scream of gas, Ataur went to the place of occurrence, that he saw Motlib dealing blow with Lenja and dagger after pushing gas into the pond, that he saw Gas' wife Asia came and requested them not to assault, accused Nur Muhammad and Ziabur attacked her with dagger. It is not a fact that I did not tell police before that Ataur saw that Ali assaulted Gas with spade and his nose got fractured, that Patarul instigated them to kill him, that Asia became senseless, that VDP secretary and president had informed police over phone that and that I was present at the time of inquest. It is not a fact that I did not tell before police that 2 days before the incident of murder, a quarrel took place between the two parties over the matter of eating of seedlings by cows, and that before that there was mutual harmony between the two parties. Accused Abdul Qadir is the husband of my sister. My sister and sister-in-law have no house of their own. I let them a plot of land near my house to reside there. In 1984, Abdul Qadir died. Before the death of Abdul Qadir, asked them to vacate the land. There was no quarrel between us, although they did not vacate the land. It is not a fact that we had bad feelings for the accused persons as they did not vacate the land. It is not a fact that it had been said that the land would be registered in the name Qadir and others. It is not a fact that as the accused persons had occupied that land, and that on the next day of occurrence, I lodged the Azahar mentioning the names of the accused persons in order to harass them, thinking that they would involve in the incident. Asia Begum did not lodge any case against me. It is not a fact that Asia lost 2 cases against me, being case number 306 of 06 and case number 900 of 06. I have not received any. It is not a fact that Asia lodged a case in the court against me, alleging that I had threatened her to involve the accused persons in this case. Nazimuddin and Forizuddin are my brothers. Patarul is my sister, and Faizur Rahman is my son. It is not a fact that I conceal the truth despite knowing that the case is true. I heard the head of the deceased was lying downward. It is lying on west-east direction. When I reached the place of occurrence, about 1,500 people were present there. Riazuddin, BDP Secretary Ataur, and President Yusuf Laskar were with me. I touched the dead body and the dead body was on an open place, and any people can go there. So far as I know, prior to this incident, deceased Gyas had no case with any people of his village. It is not a fact that VDP Secretary Ataur did not tell me about any occurrence, and that he did not tell me that the accused persons had killed Gyas and inflicted injury to Asia, and that it is not a fact that I did not meet Atwar. It is not a fact that the fact that I did not go to the place where the dead body was lying, that I did not see any injury on the body of the deceased, that no inquest was done in my presence, that I found Asia in unconscious condition, that as I have said that the accused persons did not commit any occurrence with dao, dagger and lathi, that VDP Secretary and President did not call me, and that one day before the incident, there was no quarrel between the two parties regarding the eating of seedlings by cattle, and therefore this murder took place are false. It is not a fact that I filed the case against the accused persons on false grounds. It is not a fact that the things I have said today were not written in the Azahar. It is not a fact that I did not mention in the Azahar that I come to know about the occurrence from Ataur. Further cross. My house is situated at a distance of 70 nal, 1 nal equal to 12 feet from the place of occurrence. At first, Motlib came to the place of occurrence. When Gyasuddin was working in the paddy field, Motlib came and assaulted him with a langer. Accused Mohsen Ali's house is situated at a distance of 3 kilometers from that of me. Rest of the accused persons reside nearby my house. When Gyasuddin was attacked, I was at a different place. I came to the place of occurrence when I was informed about the occurrence. It is not a fact that the accused persons in a group did not inflict injury to Gyasuddin by attacking him with sharp weapon. It is not a fact that I adduced false evidence. I am the informant of this case. Page 19, Lordship.
Yes.
I am the informant of this case. Victim, deceased late Gyasuddin was my younger brother. I know all the accused persons present in the court, but I could not say, Lordship, that how this oath was recorded again, Lordship. Because page 12 starts of PW1. Here also that page 19, PW1, Lordship, on oath. Already after cross part, Lordship. 6 September. Because first
What is
was
it, Ms. Jahan?
earlier here evidence was recorded on.
Re-examined.
Yes. Yes. 1st August 2011, the first which I have already read. And this is in the 6 September 2018. But he said almost same thing, Lordship, that cross first line. I have not seen the occurrence by myself while assaulting my brother. So that part remains same. Order. 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 May I read page 19? I am the informant of this case. Victim deceased late Gyasuddin was my younger brother. I know all the accused persons present today in the court. The occurrence took place on 8-9 years ago in the evening. At the time of occurrence, I was at Veloguri market. While I came back from market to my house, some of the village person came to my residence and they told me that I had to go to my brother's house as there was a quarrel taken place. Then I went to the house of my brother Gyasuddin. Then some of the person told me that while my brother was working in the paddy field, then accused Motlib attacked him with a spear, Jathi, on his chest and thrown him to a pond. Thereafter, accused persons Nur Muhammad, Jiabur, and Mohsen Mia assaulted him with dao, dagger, spade, etc. Thereafter, my brother was lifted up from the pond by Forazuddin and Asiya. And after 10 minutes, my brother Gyasuddin expired. When I went there, I found him dead. Police was informed about the occurrence and police came to the PO and the dead body was taken to PS. I took Asiya to Doboka Hospital, but she was referred to BP Civil Hospital and accordingly, I admitted her at Nagaon Hospital. Thereafter, I lodged the Azahar at Doboka police station. The dead body was sent to BPCH for postmortem. Inquest was done over the dead body of my brother by executive magistrate in presence of me. I put my signature in the inquest report. Exhibit 1 is the inquest report. Cross. I have not seen the occurrence by myself while assaulting my brother, but the people told me and accordingly I am deposing before the court. However, I have not seen the dead body with I have seen the dead body with multiple injuries on his body. I found the dead body on the bank of pond. PO is situated about 2.5 kilometers away from Veloguri market. I heard about the matter while I was at home. I came to know about the occurrence from Atabuddin. Zakir Hussain, Riazuddin, and Nurul Haq Maulavi, who had gone to my house and informed me about the occurrence. The pond is situated at about 15 miles away from my house. After getting information, I went to the said pond directly. I came to know from Faraz Uddin about assault. When I reached at PO, about 100 persons were gathered there, and about half an hour around 1,000 of people gathered there. At that time, all the accused persons fled away, and I did not find any one of them at PO. After about 1 hour, police had reached at PO. I was present when police arrived. Faraz was also present when police arrived. Asia was already sent to hospital before arrival of police. At the PO, Yusuf Loskor, Atabur Rahman, member Giyasuddin, Zakir Hussain had mentioned the name of accused persons before the police. Police had not asked me anything at PO, so I did not name the accused persons. I told the name of all the accused persons to police on the next day at about 11 a.m. It is not a fact that I did not state in my FIR that Motlib assaulted Giyasuddin by spear on his chest, due to which he fell down in a pond. It is not a fact that I also did not state in my police statement that accused Motlib assaulted Giyasuddin by spear, for which he fell down in the pond. It is not a fact that I did not state in my FIR that Nur Muhammad Jiabur Mosan Mia assaulted Giyasuddin by dao, dagger, and spade. It is not a fact that I did not state in my police statement that accused Nur Muhammad Jiabur Mosan Mia assaulted Giyasuddin by dao, dagger, and spade. It is not a fact that I did not state in my police statement Faraz and Asia had pulled out Giyasuddin from the pond. It is not a fact that I stated in my police statement that at the time of occurrence I was at Doboka. Doboka is 6 kilometers from Veloguri Bazar. It is not a fact that I stated in my police statement that at the relevant time of occurrence my wife was sick and doctor was giving saline at Doboka. It is a fact that I did not mention the weapon, namely spear, dagger, dao, dagger, bhojali, etc. in my statement to police. PS is situated about 6 kilometers away from the PO. I had got FIR written at Doboka by a scribe who is now dead. The FIR was read over to me. About 12 persons had accompanied me when I went to the PS for filing FIR. I had accompanied police when they taken the dead body of Giyasuddin to PO to Doboka PS. After leaving the PS, I had taken Asia Begum to Nogao for treatment. I had stayed for about half an hour at PS. When police had taken the dead body of Giyasuddin, Farazuddin was also present at the PS. I left Faraz at PS. On the next day morning, I met the police. Nearby the PO, there are houses located of Zakir Hussain, Riazuddin, late Nurul Haq Maulavi, Farazuddin, and there are other houses situated nearby. The father of accused Nur Muhammad, namely late Abdul Qadir, was the husband of my younger sister. Late Kutub Ali was my father. It is not a fact that the father of the accused Nur Muhammad Abdul Qadir had purchased the land from my father. Late Kutub Ali in the year 1983. It is not a fact that after the death of the father of Nur Muhammad, we had asked the accused to vacate the land. It is not a fact that we were having ill feelings towards the accused person as they did not vacate the land as per my asking. It is not a fact that nobody informed me at my house that a quarrel was going on involving my deceased brother Giyasuddin. It is not a fact that nobody told me that accused Motlib assaulted Giyasuddin by spear. It is not a fact that nobody told me that Nur Muhammad Jiabur Mosan Ali assaulted Giyasuddin by dao, bhojali, and spade. It is not a fact that I did not go to the place where Giyasuddin killed. It is not a fact that I did not find Faraz and Asia nearby the pond. It is not a fact that Asia did not sustain any injury and she was not admitted in hospital. It is not a fact that I have deposed falsely against the accused persons. It is not a fact that accused persons committed no occurrence. It is not a fact that I have filed false FIR against the accused persons. It is not a fact that allegation made by me in my FIR is false. It is not a fact that I was not present at the time of inquest. Now PW2, Asiya Begum, she was examined on 1st August 2011. That is prior to that re-recording of PW1's statement. Lordship. Page 22. This is Gyasuddin was my husband. Accused persons are my husband's eligible. The occurrence took place about 6 years ago. During the evening namaz, when the dark appeared, I was chopping vegetables on the veranda. My husband was uprooting seedlings at a distance of 5 nail from me. I saw him. Hearing the scream of my husband, when I gave a look towards him, I saw accused Motleb dealing a blow with a lanja near the right armpit of my husband. I went there in a run and saw that accused Nur Muhammad, he is acquitted. Accused Nur Muhammad assaulted him with a dagger. Accused Moson, that is the appellant, pushed gas into the pond and assaulted him with a spade. Gas nose got fractured. I caught my husband. The accused persons, that is illegible. Accused Nur Muhammad also assaulted me with a dao. I sustained injury on my left hand, wrist of right hand, and left shoulder. I showed the injuries in the court. Accused Motleb stepped on my back with the blunt end of lanja. Accused Patarul pushed Gyasuddin into the pond with a lathi and said that kill him. If he survived, he would create problem for us. So accused, this is illegible, assaulted Gyas with a dao. Seeing the injuries of my husband, I became senseless. Atuar, Faraj and other had arrived there before I became senseless. Thereafter, I became senseless. I regained my sense at Doboka Hospital. I was taken back home from Doboka and again taken to Nagaon Civil Hospital. I was provided treatment there. I was taken from there at about 2 a.m. on that night itself. Doctor asked me to stay there, but due to death of my husband, I was taken back home so that I could see my husband. The dead body of my husband was brought on the next day after the afternoon namaz. Later, his body was buried as per religious rites. In the course of investigation, I gave my statement at lower court and I put thumb impression thereon. Later, police questioned me about the occurrence. Now
So
cross.
there is 164 statement.
164 is there. Cross. I was alone when the accused persons were assaulting with Lanja Dao. So when assault was going on, she said, except her, nobody was there. When accused Motleb, Jiabur, and Moson assaulted with Lanja, Jiabur also acquitted, Lordship, assaulted with Lanja, dagger, and spade respectively, I was alone there. I could not rescue as no other persons was there. Seeing Gyasuddin being assaulted when I raised alarm, then other people came there. Faraj also came. At the time of occurrence, I was at the veranda, not in the paddy field. At first, I was also plucking seedlings with my husband. Later, I came home and started chopping vegetables. At that time, my daughter Hasna was at home. There are houses of other people on both sides of the road in front of my house. The accused persons claim the land as their own, in which my husband was uprooting seedlings. Kutub Ali is my father-in-law. Kutub Ali gave 1 bigha of land to the accused persons to reside there. The accused persons built a house and reside there and also started cultivation. It was the time of cultivation. The accused persons also sowed paddy seeds. The accused persons claimed that they had purchased the land from Kutub Ali. Siraj is the brother of my husband. He asked the accused persons to vacate the land, but they did not. Over that matter, there was a dispute between Siraj and the accused persons. So Siraj is the informant. In the previous year of the occurrence, the accused persons wanted to sow paddy seeds on Ghias land. Later in the year when the occurrence took place, the accused persons wanted to sow paddy seeds in the said land. I was taken back home from Dopoka hospital and immediately I was taken to Nagaon. I went to the police station after returning from Nagaon. I did not meet the police on the day of occurrence. I did not meet any police at Doboka hospital. But you're in the injury report, your lordship will find that she was identified by police. Now, who is that police personnel that is not there? My husband was uprooting seedlings at a distance of 5 knoll, 1 knoll equal to 12 feet from the house. At first, I saw Motlib and Nur Muhammad and thereafter the other accused persons came. Motlib and Nur Muhammad did not attack me first. I tried to grasp the weapon by which they attacked me. Later, I grasped the lanja with my right hand. I witnessed the occurrence from a distance of 5 knoll. The accused persons reside in separate houses in the same courtyard. Accused Motlib hacked him with a lanja. Accused Nur Muhammad hacked him for several times. Accused Nur Muhammad dealt blows on my husband, whereupon he fell and died on the spot. Other accused persons came there about 10-15 minutes after Motlib and Nur Muhammad came. So now this part, Lordship may only see that initially that Nur Muhammad and Motlib, and when he already fell, died on spot. Thereafter, after 10-15 minutes, other persons came. As I become senseless, I cannot say as to when Ataur, Siraj and Faraz came. Later, I illegible. It is not a fact that I did not tell before police that accused persons dealt thou blows to Gyas. It is not a fact that I did not tell before police that Ataur, Faraz and Siraj came to the place of occurrence. It is not a fact that on the day of occurrence I met police and I did not tell about the accused persons before the police as they were not involved in the occurrence. It is not a fact that I did not state in my statement in the court that accused Motlib had assaulted my husband with lanja. It is not a fact that I did not state. It is not a fact that I did not state in my statement in the court that accused Moson had assaulted my husband with spade after he fell into the pond. It is not a fact that I did not state in my statement given in the court that I had witnessed the occurrence from a distance of only 5 knoll from my house. Accused Jiabur assaulted my husband with dagger and fractured his nose, and the dagger was a large one. It is not a fact that I did not state in my statement given in the court that accused Jiabur and Patarul had assaulted my husband with dao and lathi respectively. It is not a fact that I did not state in my statement given before police that accused Nur Muhammad had assaulted me with dao. It is not a fact that I did not tell about my injury in the court and that did not mention the name of Ataur and Siraj. It is not a fact that I did not state in my statement given in the court that accused Motlib had assaulted me with lanja. It is not a fact that I did not state in my statement given before police and in the court that accused Patarul had asked the accused persons to kill my husband. 1 month before the occurrence, a land dispute started between us. It is not a fact that taking advantage of the said land dispute, I falsely implicated them in this incident. It is not a fact that I did not witness as who had assaulted my husband and how. It is not a fact that it is false that the accused persons assaulted my husband. It is not a fact that it is false that accused Nur assaulted Gyas with dao. Accused Motlib assaulted him with lanja and accused Rehana assaulted him with dao. It is not a fact that the injury marks on the body of my husband were old marks sustained prior to the occurrence. It is not a fact that the accused persons did not do any assault. It is not a fact that I did not see Ataur, Siraj, and Elizabeth. It is not a fact that I did not get any treatment at Nogao. It is not a fact that the accused persons are not involved in the incident. It is not a fact that I have adduced false evidence. It is not a fact that I lost case number 306/2006 and case number 900/2006 against Siraj on SN. The accused persons lived separately. The accused Moson house is situated at a distance of about 4-5 kilometers from the other accused person's house. At first, Motleb came to the place of occurrence. Hearing the hue and cry, the other accused persons came. The place of occurrence is situated at a distance of about 10 knots from my house. I became senseless after I sustained injury. At first, Motleb inflicted injury on my husband, to my husband. I sustained one injury in my left hand and 2 injury in the right hand. It is not a fact that accused persons did not attack my husband and me. It is not a fact that I adduced false evidence. Now, PW3, you'll also will find page 28. He is the VDP secretary. I know this is Gyasuddin. I know the accused persons. They are my relatives. Informant Sirajuddin is my relative. The occurrence took place about 5-6 years ago. The sun has already set. The occurrence took place just after 6 p.m. On that day, I was in the mosque situated towards the north of Sirajuddin's house for the purpose of tabligh, gathering of people for religious discussion. I had been there for 3 days. After the Asr Namaz on Friday, deceased Gyasuddin was uprooting seedlings at the paddy field situated towards south of his own house. During Azan offered at 6 p.m., I went to the mosque and offered namaz. It was a summer day. It was the month of Bhador, August, September. In the namaz, a businessman said to us, "Let's go for a walk." Then Lutfur, businessman, and I went out for a walk towards the south. When we reached near complainant Siraj's house, we heard something shouting, "I am being assaulted, I am being assaulted." Another person, that is Siraj's brother Faraz, heard a hue and cry. Faraz and I went on a run to the place of occurrence. The place of occurrence is situated towards east from Faraz's house, where Gyas was uprooting seedlings. Going there, I saw that accused Motleb stabbed Gyasuddin with lanja, pointed bamboo pole. It pierced through his left armpit and exited through the opposite side. When Gyas fell down, accused Nur Ahmed, Jiabur, Rehana, Moson assaulted Gyas with dao, lanja, hu, etc.
These people have been acquitted.
Yes.
Mutlib, Gyasuddin.
Yes. Motleb is convicted. He has absconded, but others are acquitted.
It appears he is an eyewitness to the occurrence. PW3. And state has not filed any appeal against acquittal. Is this correct?
Ataur Rahman.
Yes, PW, Ataur Rahman who saw, of course, in his, the wife, I see that she had taken specifically the name of these 2 persons, both in the, before the court as well as 164.
Right. Please examine and tell us why PW3's evidence has not been accepted by the court, is believed by the court.
He said about all had so and so, but by examining the evidence in totality, I've seen the trial court's judgment. By examining everyone's statement as to who were the perpetrators, the learned trial court found that these 2 persons are consistent in each and every statement.
So that's correct. But why PW3's statement was not accepted. Any
Of
indication?
course, there is contradiction.
All right.
There is
You point
contradiction.
out when.
Lordship.
I witnessed the occurrence from a distance of half an. It is not completely dark at that time. The occurrence took place right after the Maghrib namaz offered after the dusk. Accused Nur Muhammad, Jiabur, eligible Rehana, and Moson had gas with Dao and Ho. They used Dao. Then I saw that Faraz, shouting along, went to resist them, and that they proceeded to assault him. Then I scolded the accused persons, whereupon they left the place. Then I saw gas wipe. So PW2, according to PW3, came subsequent to that when the accused persons left. Then I saw Gia's wife. I have forgotten her name. She sustained injury when she went to save her husband. Gias was lying on the bank of the pond, and his face was facing downward. And here, Lordship, just one thing I'm pointing out, PW1 also says that PW2 fell in the pond, jumped in the pond, Lordship. And he is also saying that she went to save her husband from the pond. So the injury sustained by PW2 might have sustained during that period also.
That's all right, but PW2's injury is not the main issue here.
Lots
Issue
of-
is the homicidal death of her
Yeah.
husband.
That is there.
So even if she has not sustained injury, that will not lead to acquittal of your client unless you can show that he is not involved in committing the murder.
Okay.
Not a case of.
But if injuries goes, Lordship, then her presence will be doubtful. For that purpose, yes.
These are all hypothetical.
Lots.
All right, all right.
Lots.
You argue your
Lots,
case
lots.
according.
Then I saw Gia's wife. I have forgotten her name. She sustained injury when she went to save her husband. Gias was lying on the bank of the pond, and his face was facing downward. When I went near Gias, I found him dead. I, along with Faraz and some other people, went near the dead body of Gias. Gias' uncle Zakir also went there. As Gia's wife sustained injury, she was taken to Doboka Hospital immediately, but Doboka Hospital did not allow her admission in the hospital. And from there, she was taken to Nagaon Civil Hospital. She was taken back home. At that time, I was the VDP secretary. On that day, police came after Isha Namaz. I heard that Shiraz had informed the police. Police took away the dead body from there. I did not go to the place of occurrence when police came there. I did not go anywhere as work under job card was going on. I saw cut injury on Gita's nose. I saw injuries on several parts of Gita's body. There were about Gia's body. There were about 20-25 cuts on Gia's body. Gias was informant's brother. Accused Patarun Nasa, informant Siraz, and deceased Giasuddin are brothers and sisters. The house of Siraz, Faraz, and Gias are adjacent to each other. Patarun's house is near the place of occurrence. Later, police interrogated me in connection with the occurrence. Earlier, I gave my statement in the lower court. Exhibit 3 is the said statement. Pros. I did not tell before police that deceased Giasuddin had been uprooting seedlings from the seedbed near the pond. It is not a fact that I did not tell before police that Lutfur and I had gone for a walk towards the south. That when we had reached the house of informant Siraz, we had heard someone saying assault, assault. That when we saw another person, namely Siraj's brother Faraz, coming out of the house, that Faraz and I had gone to the place of occurrence. That we had seen Gias uprooting seedlings towards east from the place of occurrence. That when we had seen Motlib assaulting Gias with Lenja, that the Lenja had pierced through his left armpit and exited through the opposite side. That when Gias had fell down, Jiabur, Atabur, Nur Ahmed, Manas assaulted Gias with Dao, Lenja, and Hu. It is not a fact that I did not tell before police that Nur Muhammad, Jiabur, Rehana Manas had assaulted Gyas with Dao and who?
Matlib was never arrested, is it?
He was probably arrested because he faced trial. So that bail, he was on bail.
Then
That
how
part I
did
have
he
not seen.
abscond? He was on bail.
No, he faced trial till recording of the evidences, Lordship. He was there.
So how did he abscond?
Subsequently, when Lordship, at the stage of 313.
Why don't
So-
you answer the question, Mr.?
Lordship.
If he was in custody, then whether 313 or 415, what difference does it?
Lordship.
Did he run away
He-
from the prison or he
No,
jumped the
he
bail?
was outside. He was on
out.
bail. He was on bail.
He jumped the bail.
Jump bail. It's a warrant subsequent.
Ms. Jahan, can you please check out on that? Yes.
Lordship. It is not a fact that I did not tell before police that Nur Mohammad, Jiabur, Rehana, Manas had assaulted Gyas with Dao and who? Faraz had seen that and he had shouted and gone there to prevent them. That when I had scolded the accused persons, they had gone away. That Gyas' wife, Asiya, had sustained injury when she had tried to save her husband. And that I had seen 25 injuries on Gyas' body. It is not a fact that I said to police, I did not see who had what type of weapon. It is not a fact that I did not state before police that before me, Faraz had gone there, that they had chased after Faraz, that when I had asked Faraz, he said that our brother had been killed, and that, etc., went outside with a torch. My village in Bhelguri Pathar, Mikir Pathar, is the place of occurrence. During the occurrence, I was in Tabligh at Mikir Pathar Mosque. Samsuddin, Lutur, Nasir were also with me at the Tabligh. Samsuddin was a member of Masjid committee. He is alive. It is not a fact that I was not in Tabligh on the day of occurrence. The occurrence took place at about 6:37 p.m. It is not a fact that Lutfur was not with me at the mosque. It is not a fact that I did not go for a walk with Lutfur. Siraj's house is towards south from the mosque. The assault took place in the pond. I met Faraz on the road. When come out of his house, before the occurrence, I saw Gyas uprooting seedlings. Motlev assaulted Gyas with lenja. It pierced through one side of his body and exited through the other side. Motlev illegible once with lenja, sustaining this injury. Gyas fell into water. I arrived at the place of occurrence and saw that the assault was going on. Carrying torch, Nokabali and others came to the place of occurrence. Faraz did not sustain any injury. Gyas sustained injury on his left hand. It is not a fact that I did not see any occurrence. It is not a fact that I adduced false evidence. It is not a fact that Motlib did not inflict injury to Gyas by assaulting him with lenja. It is not a fact that the accused persons did not inflict injury to Gyas by assaulting him with dao, lenja, and ho. It is not a fact that the accused persons did not assault Gyas, his wife, and Faraz. It is not a fact that I did not see Gyas' injury. Now-
Let us just jump a little and go to the evidence of PW 10.
PW 10
Is the
doctor.
PM doctor?
Yes, no, he examined PW 2.
No, where is the postmortem doctor?
Postmortem doctor PW 12.
PW
PW 12 page 56.
We'll come back again to
Lots,
PW.
lots.
So which is the injury on the armpit? They mentioned about piercing armpit, right armpit.
Yes. Rest muscle. Probably that will be number 8, Lordship. Rest muscle. Rest. Really not there. I don't know. Six.
Which were the injuries found to be fatal? There's no evidence, is it?
There is no. He said only that as a result of above injuries. Page 57, top 4. Maybe. Rest.
Yes. Nine. Yes, please continue.
Lordship. Page 33, Lordship, PW4. Faraduddin. He is the brother of the deceased. Yes. Original code. Original code type.
Yes.
Postmortem. Page 33. Deceased Gyas was my elder brother. Informant Firaz is also my elder brother. Accused Patarun is my younger sister. The other accused persons are my nephew, sister's son, the husband of my niece, and the younger brother sister of my son-in-law. Our houses are located on both sides of the road. The incident took place 5 years ago. It was a Friday. The incident happened just after the Maghrib Namaz, prayer of Das by Muslims. It was not dark then. Then I was just walking on the road near my house. It happened in summer in the month of Bhadar, during the month of August, September. Hearing the scream raised by Gyas and his wife Asiya, I went near the place of occurrence. Going there, I saw Motleb stabbing Gyas with a lanja, and it pierced through his left armpit and came out through the other side. Accused Nur Muhammad hacked Gyas with a dao. Jiabur had a dagger in his hand. He hacked Gyas with that dagger. Mukaddas had a hoe in his hand, and he hit Gyas with that hoe. Asiya was also assaulted. As I attempted to go near them, the accused persons rushed at me. I raised an alarm that Gyas was being assaulted. PW3 Ataur was there along with me. He also witnessed the incident. Hearing the commotion, a neighbor also came there. Accused Patarun asked the other accused persons to kill him, whereupon they assaulted Gyas again. When the public from the surrounding area arrived there, the accused persons entered their house. Later, Atabur, Riaz, and I fished the dead body out of the pond and brought it to the bank of the pond. We also fished out Asia. So here is different story. Siraj and other villagers also took Asia to Doboka hospital with the help of police.
So this fished out is a term used by the translator. It is not in the original is in
Yes.
Assamese.
Originally in Assamese.
Fished out is obviously
Yes.
wrong. You can't fish out a live person.
Love.
So these are aberrations by the translators.
Love.
Don't bank on these things. We are not going to accept.
Lots.
This is not a contradiction. This is a mistake by the translator.
Lots. Siraj and other villagers took Asia to Doboka hospital with the help of police. Since it was a murder case and since the injuries sustained by her were grievous ones, she was not kept in Doboka hospital. Asia was taken to Nagaon hospital. Later, the wounds sustained her were bandaged and she was brought home at the time of burying the dead body. By the time we fished Gyas out of the pond, he was not alive. I saw 10-12 stab wounds on Gyas' back, cut injuries on his waist, head, and nose, and many other injuries on other parts of his body. I have seen the photograph of the deceased in the court today. Police interrogated me. Siraj accompanied me to the room in which the postmortem examination was held. Cross. Page 35. The deceased Gyas was my elder brother. My house is situated at a distance of about 200 meters away from the place of occurrence. At the time of incident, I was on the road in front of my house. Prior to that, the deceased did not have any dispute with the accused persons. The name of the father of accused, Nur Muhammad, is Abdul Qadir. After purchasing land from Kutub Ali, Abdul Qadir had been living at Mikir Pathar by erecting his house thereon. Abdul Qadir died about 8 years ago. The accused persons had a quarrel with deceased Gyas' wife, over the issue of chickens destroying paddy seedlings. It is not a fact that after the death of Abdul Qadir, Sirajuddin asked the accused persons to leave the land. Asia Begum was the wife of the deceased Gyasuddin. It is not a fact that the deceased Gyas' wife, Asia, lost a case against Sirajuddin, Najimuddin, Farasuddin, and Khairunnesa. After 2 years from the death of Gyasuddin, Asia married to another person. The place of occurrence is situated at the east-southern side of my house. I was on the road and the other members of my family were inside the house. The house of the accused is situated at a distance of about 200-300 meters from my house. Asia went to the place of occurrence first, and I went there after that. Thereafter, other people arrived at that place. It is not a fact that I did not tell Gyas that going to the place of occurrence, I saw Motleb stab Gyas with a pointed bamboo lanja, piercing it through one side of his chest and making it exit.
So I did not tell Gyas. There is some mistake here.
Yes, it should be police, Lordship. Yes. Yes.
PW1 was re-examined. I got the reason because the handwriting was too bad. The later session judge found the handwriting too bad, so again was re.
Regarding other witness also same. Lordship. Even I tried to find out those names from the original, I could not get any single word.
Who was the person who recorded this in bad handwriting? Is it possible to get the name?
There, but, uh,
M. Ahmed.
This is M. Ahmed. This is session 2000.
Okay, yes.
Applicant to the examination beleg
Yes, please.
It is not a fact that I did not state that Nur Muhammad had assaulted Gias with a dao. It is not a fact that I did not state to police that Gias hacked Gias with the dao which was in his hand, that Muqaddas hacked Gias with the hoe which was in his hand, and that Asiya was also assaulted. It is not a fact that I did not state to police that when I had raised an alarm, Ataur had arrived there and witnessed the incident, and that a person, namely Riaz, had also arrived there. It is not a fact that I did not state to police that accused Patarun had killed Gias and threw him away. It is not a fact that I did not state to police that Atabur and Riaz had fished the dead body out of the pond. It is not a fact that I saw 10-12 wounds on the body of Gias and that I did not see cut injuries on the head, side of chest, back and nose, etc. on the body. Due to my screaming, the accused person chased me to kill. The accused person did not commit any assault on me. When I reached the place of occurrence, the accused persons were assaulting Gias by putting him in the water of the pond. The water in the pond was to the level of thigh of human being. It was Motleb who assaulted first. The lenja was found penetrated on Gias' body. Jiabur dealt cut blow on the right hand of Gias with a hoe. Muqaddas hit Gias on his head. When the accused persons were assaulting Gias, I was standing on the back of the pond. It is not a fact that the accused persons did not assault Gias. It is not a fact that Motleb, Nur Muhammad, Jiabur, and Muqaddas did not assault Gias with lenja, dao, dagger, and hoe respectively, and that I did not witness the incident. It is not a fact that I was not standing in front of my house and that I did not hear any outcry. It is not a fact that when I screamed, other people arrived at place. It is not a fact that Patarun did not ask other accused persons to kill Gias. It is not a fact that Atabur, Riaz, and I did not fish the dead body of Gias out of the pond. I did not go to the hospital. I went to the police station taking the dead body along. It is not a fact that incident did not happen. It is not a fact that I have adduced false evidence against the accused. Further cross. The house of accused persons is far from that of Masadar. The place of occurrence was 90-80 knots away from my house. Going to the place of occurrence, I found Asiya. At first, Motlib came to the place of occurrence. A commotion broke out. The other accused persons came later. Later on, 2-3 persons assembled at the place. It is not a fact that accused persons did not assault the injured persons by coming there in a body along with weapons. It is not a fact that I have adduced false evidence. Now, PW5, page 39. The incident happened in 6 years ago. Hearing the commotion, I went to the field and saw Nur Muhammad. Jiabur, Motlib, Rehana, Patarun, and other persons were assaulting Ghiasuddin. The accused were armed with lenja, dao, lathi, etc., lethal weapon. I saw the incident in the flash of torch. I raised an alarm. Public gathered there and the accused persons fled. We fished Ghiasuddin out of the pond. Ghias fell into the pond as a result of the fight. Ghiasuddin died on the spot. I saw injury on the head of the wife of Gyasuddin. I saw injuries on the head, chest, and back of Gyasuddin. At that time of inquest, I was present at the place of occurrence. In course of the investigation, my statement was recorded. I showed my torch to the police. I witnessed the incident from a distance of 10 knots. My torch was a 3-cell torch from Eveready brand. On the day of incident, I inserted new batteries into that torch. Police did not seize the torch. The place of occurrence is at the east of my house. I did not find Siraj, Asiya, Ataur Rahman, and Farazuddin at the place of occurrence. It was I who went to the place of occurrence first. Now he is saying differently, Lordship, but still I have to check from the original. I did not find
It is PW5.
PW5. I did not find Siraj, Asiya is PW2, Ataur Rahman and Farazuddin at the place of occurrence. It was I who went to the place of occurrence first, and after hearing the alarm raised by me, other people arrived at the place. Now I cannot say about the weapon possessed by the accused persons at that time. I cannot say about the individual weapons of the respective accused persons for inflicting injury on the person of Gyasuddin. I did not witness Asiya being injured. I found Gyasuddin floating on water. I did not notice blood stains on the wearing apparel. Faraz is the younger brother of Sirajuddin. Now I cannot say how many injuries Gyasuddin had sustained. It is not a fact that I did not tell the names of the accused at the time of inquest. I did not hear that if accused and Gyas had any quarrel between them. I do not know if Gyas had land dispute with other people. It is not a fact that I did not see the accused persons causing injuries to Gyasuddin. It is not a fact that I had a torch in my hand. It is not a fact that I did not see the accused in the flash of torch. It is not a fact that I have adduced false evidence. It is not a fact that I saw injury on the hand of Asiya. Page 41, PW6. Deceased Gyasuddin is my cousin. The accused persons are my nephew. The incident happened at 7 p.m. Hearing a hue and cry in the field, I went there and saw Asiya and Riazuddin fishing Gyasuddin out of the water. They told me that after assaulting Gyasuddin, the accused persons had thrown him into the water and left the place thereafter. Gyasuddin had already died. I noticed stab wound on the back, chest, hand, face, and armpit of Gyasuddin. Police came and took the dead body of Gyasuddin to the place of to the police station on a pushcart. I do not know when Riaz and Asiya came to the place of occurrence. It is not a fact that I did not state to police that going there, I saw Asiya and Riaz fishing Gyasuddin out of the water, and that they told me that after assaulting Gyasuddin, the accused persons had thrown him into the water. I went to the place of occurrence from the shop of Ishaq Ali. It is not a fact that Riaz and Asiya did not tell me that after assaulting Gyas, an accused persons had thrown him into the water, that I did not go to the bank of the pond, that I did not saw injuries on the body of Gyas, and that I saw Asiya and Riaz fishing out Gyas from the water. Now PW7. The incident took place some 8 years ago. The incident took place around 7 p.m. Hearing a hue and cry in the house of Gyasuddin on the day of incident, I went there and saw Asiya and Faraz trying to fish Gyasuddin out of the water of the pond. So here your lordship will find that a hue and cry was there when they were trying to get the dead body from the water, lordship. Prior to that, there was no hue and cry. He was he was a neighbor. At around 7 p.m., hearing a hue and cry in the house of the Gyasuddin on the day of incident, I went there and saw Asiya and Faraz trying to fish Gyasuddin out of the water of the pond. I tried to take Gyasuddin out of the water and fished him out of the water. I noticed injury on the person of Gyasuddin. I noticed injuries on the nose, face, back, and chest of Gyas. At that time, Gyasuddin had already died. Asiya and Faraz told me that the accused persons present in the dock today had assaulted Gyas, thereby causing injuries to him. I have not seen accused Abdul Mutlib in the court today. Asiya and others went to his, and so I was present at the place of occurrence when the police arrived. Exhibit 1 is the inquest report, wherein Exhibit 1-2 is my signature. Cross. The pond is about 200 meters away from my house. I do not know when Asiya and Riaz came to the bank of the pond. I did not find Gias capable of speaking. It is not a fact that I did not state to police that I had learned about the incident from Asiya and Riaz. It is not a fact that I did not state to police that I had seen injuries on the nose, face, back, and armpit of Gias. I put signature in Exhibit 1 to in the police station. It is not, I do not know what is written on Exhibit 1. It is not a fact that Asiya and Riaz did not tell me that accused persons had assaulted Gias. It is not a fact that I did not fish Gias out of the water. It is not a fact that I did not see injuries on the body of Gias.
This again and again, fish out, there. Is the original record there? Can you just see what was the actual statement of the
W7.
Asiya and Riaz? We find there are a lot of mistakes already by the translator also.
We can also do handwriting. What is the actual word used by the assemblies?
উঠাবলৈ চেষ্টা কৰি আছে
Utabole.
উঠাবলৈ
That is the correct word, utabole.
Fish out is something. Fish out is when you,
yes
when something is not visible and then you dig into the water and pull out something.
Pulled out was the right word.
Pull out was the right thing. Asiya and Riaz. Who is this Riaz?
no
Yes,
Riaz is mentioning about Riaz.
Gias is deceased.
yes, is this.
Giaz says,
Yes,
somebody
yes.
says he told
Yes.
Giaz that Giaz has been murdered.
Bias is the disease.
There is no Riazuddin is PW7. PW7.
But this is the testimony, you're reading the evidence of PW7 only.
Yes, the 7 also said about Riaz.
Yes.
But who's Riaz? Is
That
there an accused?
other name I do not found in the evidence of list of
He's
witnesses.
not an accused, he's a.
No, list of
Has
witnesses.
anybody else been examined as Riaz?
No, Lordship. Only PW7 is Riaz. No other Riaz.
Cross-examination, second line.
Riaz, yeah. Asiya Riaz. This one. Riaz.
নহয়
Draw এইটো।
second line নে second
Asiya, এইটো Asiya.
I do not know when Asiya and Riaz came to the bank of the pond. Etu pisoto Riaz, no? Etu Riaz.
এইটো
Huh?
গিয়াছক উঠাই আছিলে। Asiya আৰু ৰিয়াজে গিয়াছক উঠাই আছিলে এইটো যোৱা।
I think this Riaz should be Faraz. Because of handwriting.
I did not find Gias. It was Gias. Second to Riaz ne Gias. If second to I did not hoito no hoy je.
No, in chief of PW7, he mentions about Asia, and in third line mentions about Faraz. But in cross-examination, he again speaks about one Riyaz. So whether it is a wrong recording or wrong translation.
But Assamese, it is also Riaz only. I went there and saw. Faraz होगा लगे. It Faraz है. Faraz itu তেনেকে Gias.
Yes. Feeling to back to the itu kita bisa itu
সেইটো দি গৈছে. সেইটো অফ কেনেকে অফটো এনেকুৱা.
It appears that in Chief Lordship it is said that Faraz and Cross it is said Riaz.
Your Lordship.
PW8 your Lordship will find page 45. He also same in similar tune with PW7 that on hearing, he went there and saw that they were trying to get him back from phone. I know both the parties. The incident took place about 8 years ago. Around 7 p.m. on the day of incident, hearing a hue and cry in the house of Gyasuddin, I went there and saw Gyas lying in the bank of the pond. I saw a lot of people at that place. I noticed injuries on the head and face of Gyas. I returned home out of fear. Later on, when I again went to the place of occurrence, Atabur Rahman and Riazuddin informed that the accused persons had assaulted Gyas. With the flash of the torch that I had in my hand, I saw injuries sustained by Gyas. Cross. I did not state to the police that accused Atabur and Riazuddin had informed me that the accused persons had assaulted Gyas. The batteries used in the torch did not contain sufficient charge. I saw injuries on the body of Gyas from a distance equal to the distance between this court and the road that runs in the front of this court. It is not a fact that Atabur and Riazuddin did not tell me that the accused persons had caused injuries to Gyas. It is not a fact that I did not find Gyas in injured condition on the bank of the pond. It is not a fact that I have adduced false evidence against the accused persons. PW9. The incident happened about 8 years ago. Hearing a hue and cry near the house of Gyasuddin, I went there and saw that Gyas' wife, Faraz, Atawur, Riaz, and others had fished Gyas out of the water. I noticed an injury extending from the forehead to nose and mouth, and other injuries on the back and waist of Gyas. I assume that those injuries might have been inflicted with dagger. Faraz, Ataur, Riaz, and Gyas' wife informed me that the accused had assaulted Gyas and thereafter threw him into the water. I made phone call to police and police arrived accordingly. Police took away the dead body of Gyas. Inquest on the dead body was held in the police station. Exhibit 1 is the inquest report. I noticed injuries on the hand and forehead of wife of Gyas. Gyas' wife told me that when she went to save her husband, the accused persons inflicted injuries on her. It is not a fact that I did not state to police that I could learn from Gyas' wife, Faraz, Faraz, Riaz, and others that the accused had assaulted Gyas. I did not state to the police that I had seen injuries on the person of Gyas' wife. I did not state to the police about Gyas' wife telling me that she had sustained injuries. It is not a fact that I did not state to police that going to the place of occurrence, I had found the accused persons there. It is not a fact that I did not state to police about the injuries sustained by Riaz. When I informed the police, I did not tell the name of the accused. I do not know what is written in Exhibit 1. It was already dark at the time of incident. It is not a fact that Faraz and others did not tell me that the accused persons had assaulted Gyas. It is not a fact that Gyas' wife did not tell me that the accused persons had assaulted her. It is not a fact that I did not go to the place of occurrence. Now, PW10 is a doctor who examined PW2. On 5/6/2005 at 11:55 AM, I examined Mrs. Asiya Begum, aged 30 years, and found incised wound 3 on right wrist exterior surface, middle part of lateral side of left arm, and middle part of right arm caused by sharp weapon. Nature of injury was simple. Patient was admitted in hospital in female surgery ward on 5/8/2007, but the patient was not available in ward to follow up. Exhibit 5 medical certificate. Age and column of injury, PS case number not mentioned. Such injury might have been caused by one falling over sharp articles. No scale was used to measure the length and breadth of the injury. Insight was determined on the basis of age and surface of injury. It is not a fact that victim had not sustained incised wound. Now PW. Period 13.
11.
Yeah, sorry, I'm PW 11. Sri Ashok Kumar Datta, he is the IO. On 5/8/2005, while I was working as SI of police at Doboka PS, on that day, the OC Doboka PS made a GD entry number 112 dated 5/8/2005 on the basis of information received from one Moinuddin regarding the murder of one person, Gyasuddin, by some unknown person, and also for committing assault to his wife. The OC made the GD entry and directed me to investigate the case. On the same day, I visited the PO situated at Sangmaji Mikir Pathar village. I prepared the sketch map of the PO. I also recorded the statement of witnesses. The dead body of the victim was brought to PS. Though I searched for arresting the accused, but I could not arrest them. The inquest was done by magistrate at the PS. The dead body was referred for postmortem. On 7/8/2005, I arrested accused Patarun Nessa and Rehana Begum. I forwarded the witnesses Asiya Begum, Farasuddin, Zakir Hussain, and Ataur Rahman to the court for recording their statement under section 164 CRPC. On being transferred, I handed over the case diary to the OC. Exhibit 6 is the sketch map of the place of occurrence. Exhibit 6.1 is my signature. Cross. PW Abdul Karim did not state before me. 9. Abdul Karim did not state before me that he came to know from the wife of the deceased Gyas and from Riazuddin regarding the murder caused to Gyasuddin by the accused person. The said witness also did not state before me that he found the accused persons at the PO. PW Riazuddin that is PW 7, did not state before me that he came to know from Asiya Begum regarding the occurrence. The said witness did not state before me that he found injury on nose, mouth of Ghiasuddin. Abdul Jalil, PW 6, did not state before me that the accused persons caused murder to Ghiasuddin and threw him to water, and he brought out the dead body from the water. The said witness also did not state before me that he came to know about the occurrence from Asiya and Riazuddin. Farasuddin, PW 4, did not state before me that he saw accused Motley when he inflicted the blow by bamboo. He pushed the bamboo on the side of the chest. The said witness also did not state before me that the accused Nur Muhammad inflicted the blow of dao on Ghias. The said witness also did not state before me that the accused persons take away the dagger from the hands of victim Ghias and inflicted the blow on the Ghias. The said witness also did not state before me that the accused gave a blow by a spade to Ghias and to his wife Asiya. The said witness also did not state before me that after hearing his alarm, some persons, namely Atuar and Riaz, came to the place of occurrence. The said witness also did not state before me that accused Patarun Nasa caused murder to Ghias and threw him away, and Atabur and Riazuddin brought out the dead body of Ghiasuddin. The witness Ataur Rahman 3 did not state before me that victim Ghiasuddin was planting and the champling of paddy. The said witness also did not state before me that after hearing the shouting, he and Lutfur went to the place of occurrence. And at that time, Faraz also arrived at the place, and along with Faraz went to the PO immediately and noticed Ghias when he was planting the champling the paddy. And accused Motlev was assaulting to Ghias by means of Jati, Ranja. The said witness also did not state before me that he penetrated with Lanja on the left arm of victim. Then Ghias fell down, and then other accused assaulted him by Dao and Lanja. And at that time, Ataur Rahman was witnessing the incident from nearby place. The said witness did not state before me that Nur Rahman, Ziaur Rahman, Rehana, Mosad assaulted to Ghias by means of spade and dao, and at that time Faraz came, and also seeing Faraz, accused left the place. At that time, wife of Ghias came, and after seeing her, accused also assaulted her and caused injuries. The said witness also did not state before me that he did not see what type of weapons were in the hands of each accused. The residence of Nurul Haq and victim situated just north side of the place where the dead body of Ghias was found lying. The residence of Zakir, Nawab, Riazuddin, Abdul Karim, Aftabuddin situated just western side of the place of occurrence. No any article was seized from the possession of the accused persons. No any weapon was seized from the PO. No name of accused was mentioned in the GD entry. The information regarding the occurrence received after half an hour. I arrived at the PO at 7:30 p.m. I found the informant and the other witnesses there. On the same night, I referred Asiya for medical treatment at about 11:55 p.m. On 6/8/2005, the FIR was registered by OC at 8:30 a.m. The family members of Ghias were also at the police station. It is not a fact that on the same night, no any name of accused was mentioned by family members of Ghiasuddin before me. So no FIR was lodged at that night. So there was delay in lodging the Ejahat. PW2 Asiya Begum did not state before me that accused persons caused death to her husband by inflicting the blows of Dow. The above PW also did not state before me that accused Mosaddar Ali, that is the appellant, had come to the place of occurrence. The said witness did not state before me that accused Jiabur inflicted the blows of dagger on her husband and the dagger was broken one. The above witness also did not state before me that accused inflicted the blows of fall on her husband. As per statement of witness Sirajul recorded by me, he is not the eyewitness and he came to know about the occurrence from the village people. The said witness also did not state before me that accused penetrated the dhow on the left side of the chest of Gyasuddin. The above witness also did not state before me that the accused inflicted blows with lanja and dhow and threw the victim to the pond. But above witness also did not state before me that the accused inflicted blows of dagger to Gyasuddin and caused his death. The above witness also did not state before me that accused Mosaddar Ali gave the blow of spade to Gyas and other accused instigated him. It is not a fact that I could not collect the material is the accused. Huh?
You read the evidence of PW? Just now you read.
PW11. PW11.
What is the next evidence? Page 55?
Page 55 is further crossed.
That is the IO.
IO. PW11 further crossed.
All right. We'll continue after lunch.
Logic.
This matter will take some time.
Because contradictions are there. So only in respect of the wife, I think contradictions are less as far as her seeing the incident. Others, there are contradictions.
We'll continue.
Gotcha.
For me, that accused Nur Muhammad assaulted her husband with dhow, but she has stated before me that her husband was assaulted with dagger. Police got information about the incident at 7:30 p.m. on 5/8/2005. Police reached at the PO at 8 p.m. After reaching at PO, police found Moniruddin, who has informed police over phone, and we examined him at the PO itself. It is a fact that Moniruddin has not been cited as witness in the charge sheet. He is vital witness, but he is not cited. Charge sheet, and his statement was not recorded under section 161 CRPC. Upon arriving at the PO, as soon as I did not find Yusuf Laskar Abdul Rahman, member Gyasuddin, but we find Zakir Hussain. On the next day of the occurrence, that is 6/8/2005, I examined Firazuddin at PS and recorded his statement. According to the CD, the statement of Sirajuddin was recorded with endorsement of date on 7/8/2005. Witness Sirajuddin did not state in police statement before me that accused Motleb assaulted Gyasuddin by spear in his chest, due to which he fell down in the pond. PW1 Sirajuddin did not state in police statement before me that accused Nur Muhammad, Jiabur Rahman, Moson Mia assaulted Gyasuddin by dhow, dagger, and spade. PW Sirajuddin stated in police statement before me that Faraz and Asiya pulled out Gyasuddin from the pond. PW Sirajuddin had stated before me that on Friday he had gone to Doboka. PW Sirajuddin stated before me that he had gone to Doboka with his wife, and his wife was sick, and doctor given her saline at Doboka. PW Sirajuddin did not mention about spear, dhow, dagger, etc. in his statement. The statement of PW8 Farazuddin was recorded on 5/8/2005 at PO. PW4 Farazuddin did not specifically state in police statement before me that Motleb inserted spear in the chest of the victim. PW4 Farazuddin did not state before me that Mosan assaulted the deceased with spade. PW4 Farazuddin did not state before me that Jiabur had dao in his one hand and a dagger in his other hand. No any weapon was recovered from the PO. Upon reaching the house of accused persons also, no any weapon was recovered. Now, medical officer, your lordship has seen earlier, that PW12 who conducted postmortem of dead body, lordship. Just one thing, if I may point out, lordship, that in cross.
Chest.
Chest,
Armpit, chest.
This is rest or chest?
This is wrist, WRI, this is wrongly.
No, injury number 8 in
Eight.
page 56.
This is sharp cut. injury.
Left rest, what is left rest?
No, this is wrist actually, wrist. Wrongly. Because in the PM report, it is wrist.
Paper report, I record it, type copy of PM,
PM report type
type copy.
There it is written wrist, see?
Is the type copy. In paper book, the postmortem report is type copy.
Otherwise, at page number 124, it is wrist. Original. WRI.
Yes.
From the medical officers, lordship, just one thing if I may point out, lordship, that he said that death was in cross, lordship, he said that death was caused about 24 hours before the time of examination. And examination was done on 6/8/2005 at 3:30 PM. So by that, lordship, it will be in daytime by his death, lordship.
These are all opinions. These are not gospel truths.
That is
You
there.
know the quality of doctors
But-
working in these hospitals. They are very reluctant. Somehow they go there and come back. They will not write things correctly. They will not examine anything. Just because they want the salary, most of them go there and very reluctantly they will go. You can see the apathy.
Lordship,
Injuries are not even properly recorded.
lordship.
So in reality, he might not have even seen the body. Somebody might have
That-
come and told him that you write this. So this is the state of affairs which you know, we know, everybody knows. So let us not put too much
I'm not,
emphasis on these things. If on the overall assessment of materials, we find that this is a
lordship.
case which is not made out, there will be acquittal. If we find that some lapses here and there, but it has happened, we'll find a way to
Lordship.
reach there. Yes,
Page 56, lordship. Prasanta Bijburua,
page 56,
56, 58, lordship, sorry, 58.
58.
Here's another IO, lordship.
Another IO.
Lordship. On 27/10/2007, I was working as SI at Doboka PS. On that day, I was handed over the Doboka PS case number 36/05 to complete the further investigation of the case. On perusal of the CD, I found that the investigation of the case was almost completed. One of the accused, Mosan Mia, was not arrested, and the medical report of Mosammed Asiya Begum was not collected. I collected the said medical report from BPCH I arrested the accused Moson Mia on 11/2/2008. I interrogated him and thereafter I forwarded him to judicial custody under objection. During his interrogation, the accused Moson Mia confessed his guilty and he stated before me that on the day of occurrence, he along with the other accused Motleb, Ziaur Rahman, Nur Mohammed, and Patarun Nessa, when they were working in the bank of Pond, they killed Ghiasuddin. Firstly, accused Motleb assaulted with Jathi, and since he, Moson Mia, assaulted by spade, which was in his hand at backside of Ghiasuddin. Then Ghiasuddin fell down in the bank of the pond. Thereafter, accused Ziabur and Nur Muhammad assaulted him with dao and dagger. At the same time, the accused Rehana Begum and Patarun Nessa assaulted with dao. Victim Ghiasuddin was fell down in the pond. At that time, his wife Asiya Begum came and requested them not to kill her husband, but accused Rehana Begum assaulted her with dao. Motleb also assaulted her with Jathi by saying to finish her. He, Moson Mia, also trying to cut Asiya Begum with dao, but he did not say whether she caused injury or not. All the accused persons were leaving the PO after getting a hue and cry of the public. The dispute arose between them as the cattle destroyed the germinated paddy plants. Accused Moson Mia also confessed before me that he committed the offense due to instigation of other accused, namely Motlib and others. As the investigation of the case was completed, hence I submitted the charge sheet against the accused persons under section so under objection. Is the confessional statement? Cross.
Confessional statement made
Before the
IO.
police, before the IO.
Don't forget it.
Cross. There was no any prayer made before the court court below for recording confessional statement of accused Moson Mia at the time of forwarding him to the court. The copy of statement of Moson Mia recorded by me by Exhibit 7 was not annexed with the forwarding report. Here, Lordship, they said, Lordship, the day when he was forwarded, on the same day he confessed before the police. Therefore, this question was put to him. There is no any signature of accused Moson Mia in Exhibit 8. There is no endorsement in Exhibit 8 that the statement was read over to him and he admitted it to be correct. There is also no any endorsement in Exhibit 8 that accused Moson Mia was made aware that his confession may be used against him. I did not file the copy of Exhibit 8.1, the statement of accused Moson Mia, with the charge sheet. After arrest, the statement of Moson Mia was taken in police station. The date of occurrence is 5/8/2005, and I recorded the statement of Moson Mia on 11/2/2008. It is not a fact that I have no power to record confessional statement of accused under section 2526 of the Evidence Act. Only 161 CRPC is applicable for witness. There was no any recovery of any weapon or any incriminating article from accused Moson Mia. We have searched the house of Moson Mia, but we have not found anything from his house. Accused Moson Mia was not medically examined prior to recording his statement, although he was medically examined after recording his statement. It is not a fact that accused Moson Mia did not admit and confess before me that he and other accused assaulted and killed Ghiasuddin and caused hurt to Asiya Begum, and therefore I did not submit any application before the court below to record his confessional statement. It is not a fact that accused Moson Mia did not state before me that at first Motleb assaulted Ghiasuddin by Jathi, and thereafter he assaulted Ghiasuddin by a spade, and thereafter Ziabur and Nur Muhammad also with dao and dagger assaulted Ghiasuddin, and then Rehana Begum and Patarun Nessa assaulted Ghiasuddin by dao, and Rehana Begum assaulted Asiya by dao, and Motleb assaulted her by Jathi, and he took dao from Patarun Nessa and assaulted Asiya Begum by dao, and at the instigation of Motleb, he committed such act. It is not a fact that Exhibit 8.1 is false. I had arrested Moson Mia from his house. Mr. Ashok Kumar Datta was the IO of the case. He had investigated the case and he recorded the statement of the witness. I had not recorded the statement of the witnesses as those were already taken by the IO. I have not forwarded Asiya Begum for treatment. I only collected her medical report. It is not a fact that I filed a charge sheet against the accused without getting any medical material or evidence against the accused persons. The page 60 is the EO who, let's say, who executed the warrant of arrest against that Abdul Mutlib. He deposed to that effect. So these are the evidence, Lordship.
Hmm.
And what I find from the evidence, Lordship, that Mosonbia,
EW, what is EW? Page
Inquiry-
60,
page 60, EO,
what is EO?
executing officer, that a warrant of arrest was issued against Abdul Mutlib. PNL was also.
Yes.
So these are the evidences.
I think that judgment against Abdul Motif will be a nullity, of course, subject to correction. Because he absconded after 313 and his case was filed. I've seen in the audition.
That is what we asked in the beginning.
Hmm.
He's saying if the accused is present while the evidence is recorded,
Hmm.
then it will not be a nullity. That's what he's saying.
But then I found in the records, the case was filed against Motlib.
Case was?
Filed, it was separated.
It was separated. So if
Ah.
separated, then that submission will not come.
As far as he is concerned,
It
I
was
think
not a joint trial.
it was a joint trial.
Separated means what?
Like whenever someone gets absconded, goes away, his
Hmm.
case is separated from the rest. His
So
case will be
tomorrow,
heard.
if the police can nab this man,
Hmm.
then he will again be subjected to trial.
Not trial, from 313 again, he will be subjected to, I think.
That is what
Defense
is
and all.
trial.
Yes. Argument will be heard in respect, because argument was not heard in respect of Abdul Mutlib.
But
But entire judgment will not go as far as.
But he has
Musandra-
been convicted.
He has been.
Then how he has been convicted?
That is what was a mistake in my hand.
Acha, what has the police done to arrest him? What efforts were taken?
This is what EO has also said, and I have also found in the charge, the order sheets, they have issued first warrant of arrest
He
was
has been
issued
absconding since when?
2008, 2000, he absconded on, because the 2018. He was with steps till 16/11/2018.
Hmm.
3/12/2018, he was without any steps. He did not come without steps.
Hmm.
Warrant of arrest was issued. Then on 12/12/2018, NBW, thereafter NP.
So he was granted bail. There must have been a surety. What
He-
action has been taken?
Guarantor, they proceeded against the guarantor.
Hmm.
And then nothing happened, and then his case was filed.
No, but now things will have to happen now. Who will come and answer these questions?
After he is arrested, then only now I tried to find out whether something had happened in between. He had filed any appeal, but there is none in the High Court.
We would like to know what action the police has taken after event absconding.
That is.
Against him, probably standing warrant is there.
Hmm?
Against him, standing warrant
Warrant
is
is
there.
there.
Yeah, but what action has
That-
been taken to
yes.
execute the
That
warrant?
has to be executed.
Second, what has happened to the surety?
I find something against the guarantor. Baylor, notice, Abdul Muttalib is absent, NBW and Baylor notice also not returned.
This is which police station?
Ajay. Ajay, no? Ajay,
Doboka police station.
Daboka police station.
You have to get us that information from the SP. Or
Ah.
we'll call him.
Hmm.
Complete information, what has happened.
PNA was issued as was stated by EO, the executing officer.
Hmm.
I came to know that accused has been residing at Chennai since 2 months.
Hmm.
So I served PNA in presence of local VDPs and the copy of the warrant of arrest kept at police station for further attempt. I have not found any property in the name of the accused. Exhibit A is the proclamation order, A1 is the signature, order of attachment is my report and my signature. 2018 or 2019, 7/2/2019. Now
You have
what
to get
police,
us all the information.
I'll get the instruction from Daboka police station, what,
Get it from the SP.
not sure.
Otherwise they will have to come and tell us what has happened.
Registry nala ke ami karu. I'll get it done. What my learned friend is saying through registry, but I can also speak to the.
Nothing, directly, what registry?
No, I'll
You-
speak to the
you
SP.
Tell us. Get the information from wherever you
Hmm.
want.
Fine.
What action has been, but we'll continue with the hearing.
Lot.
But then we may not be able to close it today. In any case, the court has to also rise early. There is some meeting.
Oh, acha.
Somehow.
Lordship has a single bench.
Single bench is there. There is some Nalsa meeting,
Acha.
Supreme Court. But that's all right. The point is, prima facie, this is wrong. He could not have been convicted.
Hmm.
But now that it is before us, we have to deal with it.
But he is not before your lordship. As far as he is
The
concerned,
issue is before us, the judgment is
Ah.
before us.
yes. Whether the entire judgment will go, that I have to again look into.
And
That- Filed order.
your client is in jail.
He is in jail.
Filed order is done on 18/3/2019. After these EOs,
This is called file.
case was separated.
When you separate a case, this is called file.
It is called filed.
These are.
FILED.
So if it was filed, then how could the judge convict him?
Without argument and all.
That means the trial for the absconder was halted at that stage.
Halted at that stage.
Although in the judgment, it is written that he absconded after 3:13. But as I have pointed out before your lordship, the initial, in the morning hour, that in his 3:13 statement, his signature is also not there.
His signature is not there.
All right, you proceed. Let us see the judgment.
Judgment starts from page 91 and paragraph 10 at page 100 starts the reasoning.
Let us see what are the findings.
Lordship. In cumulative and careful analysis of evidence on
Number,
Lordship,
page
page 100, paragraph 10 of the judgment. In cumulative and careful analysis of evidence on record in entirety, it surfaces that the informant is the brother of victim Yasuddin, who has stated in his evidence that the occurrence took place about 8-9 years ago in the evening, while he was at Veloguri market. While he came back from market to his house, some of the villagers came to his residence and told him that he had to go to his brother's house as there was a quarrel. Then he went to the house of his brother Gyasuddin. And then some of the person told him that while his brother was working in the paddy field, then accused Motleb attacked him with spear, Jathi, on his chest and thrown him to a pond. Thereafter, the accused Nur Muhammad, Jiabur and Moson Mia assaulted him with dao, dagger, spade, etc. When he went there, then he found the dead body of his brother Gyasuddin. Police was informed and came to the PO, and the dead body was taken to PS. He took Asia to Doboka Hospital, but she was referred to BP Civil Hospital for better treatment. Thereafter, he lodged an Azahar at Doboka PS and the same is testified by him as Exhibit 2. Inquest was done over the dead body of his brother by the executive magistrate in presence of him. He put his signature in the inquest report. Corroborating the facts, and ocular witness as well as victim PW2, Asia Begum stated that the occurrence took place 17/1/2011. At about 8-9 years ago in the evening, the accused Abdul Motleb assaulted her husband with a spear on his stomach, and accused Mosanme assaulted her husband with spade on his forehead, due to which his nose was cut. Accused Jiabur also assaulted him with dagger. Accused Rehana Begum assaulted her with a boti dao on her both hands. Somehow she took her husband to the bank of the pond. In the meantime, Farasuddin came to the PO. Then accused person chased him with dao and lathi. Thereafter she became senseless and she was taken to hospital. Her husband was also taken to hospital, but the doctor declared him as dead. In consistency with PW3, Atwar Rahman revealed in his evidence that at the time of occurrence, he heard hue and cry at the paddy field and he went there. He saw that accused persons Abdul Motlib, Nur Muhammad, Jiabur, Moson Mia, Patarun, and Rehana threw his elder brother Gyasuddin to a pond. Accused Motlib assaulted him with a spear on the chest of his brother. Accused Nur Muhammad assaulted with dao. There was a dao in one hand of Jiabur and a dagger in his other hand. Accused Moson assaulted his brother with a spade. He saw the occurrence by himself while assaulting, and thereafter the accused person tried to assault him and seizing him, but they could not assault him as he fled away by screaming. PW4, Farazuddin stated at the time of occurrence, he heard hue and cry at the paddy field, and he went there. He saw that accused persons Abdul Motleb, Nur Muhammad, Jiabur, Moson Mia, Patarun, and Rehana threw his elder brother Gyasuddin to a pond. Accused Motleb assaulted him with a spear on the chest of his brother. Accused Nur Muhammad assaulted with dao. There was a dao in one hand of Jiabur and a dagger in his other hand. Accused Moson Mia assaulted his brother with a spade. He saw the occurrence by himself while assaulting, and thereafter the accused persons tried to assault him. The victim, deceased Gyasuddin, died on the spot as a result of assault by the accused persons. Without any departure, PW5 Zakir Hussain stated in his evidence that he saw Nur Muhammad, Jiabur, Motlib, Patarun, and another one were assaulting Gyasuddin. They were equipped with lethal weapon like dao, lathi. He saw the occurrence and he started shouting, and thereafter persons of the locality gathered there, and then all the accused fled away. They brought out Gyasuddin from the pond. He also saw the injury on the hand of wife of Gyasuddin and the injuries on the head, chest, and backside of Gyasuddin. He was present at the time of inquest. In cross, he stood firm in his evidence in chief. PW7 Riazuddin stated in his evidence that upon hearing hue and cries in the house of Gyasuddin, he went there and saw that Asia and Faraz trying to bring up Gyasuddin from the pond. He also assisted to bring out Ghiyasuddin from the pond. He had seen injuries on his face, backside of Ghiyasuddin. PW8 Nawab Ali Laskar stated upon hearing screaming near the house of Ghiyasuddin, he went there and saw that Ghiyasuddin was lying in the bank of a pond. A number of persons there. He had seen injury over head and face of Ghiyasuddin. PW9 Abdul Karim stated in his evidence that upon hearing screaming nearby the house of Ghiyasuddin, he saw that the wife of Ghiyasuddin, Faraz, Atabur Rahman, Riaz, etc. were trying to bring out Ghiyasuddin from water. He had seen the injury on face, nose, and the backside of Ghiyasuddin. Thus, on meticulous perusal, I find there is consistency in their evidence which inspires confidence of the prosecution case. To the extent of injuries, the medical testimony, that is PW10 Dr. Lalit Chandra Nath, corroborated the fact that Asiya had incise wound of 3 inch on left wrist extension surface, multiple part of lateral side of left arm, and multiple part of the left arm caused by sharp weapon. Nature of injury was simple. In respect of deceased Ghiyasuddin, PW12, Dr. Keshav Sarveshwar Bora corroborated to the extent of injuries that Ghiyasuddin had sharp cut injury on forehead measuring 4 inches. A sharp cut, those injuries I am skipping, Lordship. In his opinion, the cause of death was due to shock and hemorrhage as a result of above injuries. The investigating officer PW 11 and 13 stated in their evidence that firstly, accused Abdul Motlib assaulted with Jathi, and since Moson Mia assaulted by spade, which was in his hand at backside of Ghiyasuddin, and then Ghiyasuddin fell down in the bank of ponds. PW 11 and 13 are the IOs, Lordship. There is no any impeachment or iota of doubt on the credibilities of the prosecution witnesses. And thus, I find that testimonies of prosecution witnesses are trustworthy and reliable. However, there is nagging doubt on active and concerted participation of accused Nur Muhammad, Jiabur, Fatarun, and Rehana Begum in commission of alleged offense as the vital witness PW2 Asiya Begum, who also sustained injury, stated unambiguously in the cross that accused Motleb first assaulted her husband, then accused Moson alias Mosaddar Ali assaulted her husband, and then her husband fell down in the pond. When the victim fell down in the pond and thereafter, in what way and manner other accused persons assaulted him is associated with vagueness, and thus on that count accused Nur Muhammad, Jiabur, Fatarun, and Rehana Begum are entitled to benefit of doubt. Nevertheless, it is distinct and proved beyond all reasonable doubt that firstly accused Abdul Motleb assaulted with Jathi and Moson Mia assaulted with a spade on the backside of Ghiyasuddin, and thereafter the victim Ghiyasuddin fell down into the pond. That in next paragraph, that confession was discarded. Learned Defense Counsel has rightly submitted that the confession made in police custody cannot be said to be voluntary. As such, any confession of Moson Mia was in police custody, which is not admissible under Section 25 of Evidence Act 1872. It's axiomatic that no confession made to a police officer shall be proved as against accused of any offense. In that light, the confessional statement of accused Moson Mia, that is Exhibit 8.1, cannot be proved used against accused Moson Mia as it was made to a police officer. Notwithstanding of the fact stated above, it has all been proved beyond all reasonable doubt by other ocular witnesses that firstly accused Motlib assaulted with Jathi and accused Mosaddar Ali alias Moson Mia assaulted with a spade on the backside of Ghiyasuddin, and thereafter the victim Ghiyasuddin fell down in the pond. To which the prosecution could bring home beyond all reasonable doubt against the accused Abdul Motlib and Mosaddar Ali alias Moson Mia. that they killed the victim Gyasuddin on 5/8/2005 at about 7 p.m. Subsequently, it is held that there is no ingredient of section 147. So unlawful assembly, that charge was dropped.
What vagueness in this? Vagueness, the judge doesn't say contradiction, it says vagueness.
Yes, judgment cannot be supported because he also relied on police statement, although saying that this is not applicable, but then first paragraph he said that he had confessed, only these two people had done. Vagueness in the sense that few of the witnesses have in an omnibus way had stated that all these people have attacked. A contradiction is there. As far as PW2, contradiction is less.
You have a list of the contradictions.
I'll make it.
Do you have it?
No.
No, I haven't.
That's what I was thinking. I'll make what he had stated in and what is the contradiction.
And even also here it is said that PW2 name only 2 persons, but if your lordship see the cross examination, PW3 name more than 2. Lord.
PW2.
Yes, in cross also she said mention about presence of other who assaulted the deceased. And what I find lordship subject to correction here, lordship, that Abdul Motleb absconded. Because of that reason, he convicted and confession was there in respect of the present appellant. Therefore, these 2 persons were convicted.
This will not be again, cannot be effect. 164, she had implicated only these two.
But
PW.
164 has nothing. just
Corroboration, yes.
For corroboration purpose. Can't be used even for contradiction.
It can be used for contradiction.
Hmm.
There are the difference of judgments. In few judgments, I find only corroboration. In few judgments, I find both.
Let us see. IPC, CRPC.
One or two, sir. 52.
164.
164. Equity. Statement of witness. Witness. It is very three by four. Any such confession? Witness. Witness, any statement other than a made under corroboration for judgments.
Anything?
Mm-hmm. Was with matlab. That's all. The whole. Honestly.
This statement under 161 CRPC can
Con-
be used for contradiction
Only.
only.
Mm.
What about 164?
It can be used for both in some judgments of Supreme Court said.
And in some judgments says only for
Corroboration.
It is only for corroboration or contradiction.
Both, I think.
Is there any judgment which says only for corroboration?
One Shaji judgment is there where it is said it can be used for both. Supreme Court. In fact, Justice Sandeep Mehta also told me once, it can be used for both. I said only corroboration. He said, no, it can be used for.
I have read some judgments, some literature where
Hmm.
the opinion was given that it can be used only for corroboration.
Even I felt like reading, but later on I found few.
But it defies logic
Hmm.
because this is a previous statement.
Hmm. But again,
So if
before
there
the
is
magistrate.
If there is any discrepancy, then the defense side would definitely be able to contradict the witness. Anyway, I will not get stuck up in that.
In fact, in 164, she implicated all the persons that they assaulted the deceased. With dao, spade, with arms, she has described it. In page 111.
164, she means the wife of the deceased.
Yes,
She
PW2.
has implicated everyone.
Everyone.
And in the deposition also she is implicated.
Yes, implicated.
Then why is her evidence not good enough to convict all of them? That's the question we are asking.
My submission to lawsuit is that PW2 and PW6 are contradicts each other. Because PW2 says when I was there, the incident occurred and no one else was there. And PW6 says similar thing, lordship. That immediately I went there, no one was there. Subsequently, other persons came.
This will raise a question mark on whether they were there or not.
Lordship.
It cannot raise a question mark on whether the incident happened or not.
No, whether they have witnessed the incident, because PW2 is regarding PW6.
Forget everything else. Why PW2's evidence should not be taken on the face value? Give us one reason. Why it should not be? Because it finds corroboration from at least her previous statement. She has not been able to be, could not be shaken. She's remained firm. She is an injured witness. It is her husband. She went to save the husband. She has named and implicated all the accused persons. So between two other witnesses, who was there first and who was there second, how does it got to do anything with whether the accused person that killed?
Whether she is reliable or not,
They are all, let us discard their evidence. Why two is not reliable?
So whether she is reliable or not, because immediately after the incident, police was informed, police came to the place of occurrence. Police says police sent her to medical and she did not disclose at the initial point or name of the assailants, lordship. Subsequently, she disclosed all those things.
You have to also answer to us that why there no judgment against acquittal was preferred in this case. Because we are going to write a judgment here. If we find that the state is handling these matters in a very apathetic, in a very mechanical manner, it should come out. Public should know.
In fact, evidence are against all. I may say something or the other, but then the fact remains even in 164, she had stated about all and with overtax. One has used this, one has used.
Short of making some serious comments about the judge also. What is this way of writing a judgment in a murder case? Vagueness. But then why have you accepted this? Unless you give a good answer, you will be acquitted.
Yes.
Saying that this is the desire of the state. We'll mention it.
Because unless the public
that
prosecutor.
law is correct. Same set of evidence, someone is acquitted, someone is not, and the state accepts acquittal. We'll mention that the state desires that this appellant should also be acquitted. And this judgment will remain in domain. public domain. You better,
No, unless the public prosecutor writes to us, we don't do anything. We are not even aware of these judgments unless appeal comes. So there is a mechanism and it is not followed in the proper manner,
then mention it in judgment.
because otherwise this acquittal of these people were wrong in the face of it.
Why no appeal was preferred? You have to tell us that.
In the totality of the evidences, he has taken into account only these two people because
Why has he taken into account? Because you have to tell us, because you means not you individually, the state. Because we find that there are substantial evidence against all of them.
even if we discard PW 1, 3, 4 and all, 2 also had stated about them. But let me go through 2 once more. 2 had, in her examination in chief, she had stated all of them. Nur Muhammad assaulted with dagger, Mosun pushed Gias into the pond, assaulted him with spade, etc. In her cross-examination also, she said, when accused Motlib, Jiabur, Moson assaulted with lenja, dagger and spade respectively. I was alone and I could not rescue. So she had here named only Motlib, Moson, and of course Jiabur is there on the very first line of her cross-examination. But Jiabur is there. And again in her cross-examination, she said, I first saw Motlib and Nur Muhammad, and thereafter other accused persons came. Motlib and Nur Muhammad did not attack me first. She is talking about herself. Then Motlib hacked him with a lenja. Nur Muhammad hacked him for several times. Nur Muhammad dealt blows on my husband, whereupon he finally died. She did not name Moson. Then again in the further cross-examination, she said, accused Motlib had assaulted my husband with lenja. It is not a fact, I did not state in my statement in the court that Moson had assaulted my husband. Here she again names 2. Only Motlib and Moson. But again, Nur Muhammad and...
There is one thing. There are judgments, even I think some of them are authored by me also, that discrepancies can be there. But to assume the characteristics of contradiction, it must be such that 2 statements cannot coexist.
Yes.
It could be either this or that,
that.
and the witnesses said both. Then it becomes a contradiction. But something in, say, one place she named 3, in another place she named 4. That is not contradiction.
That is not contradiction, yes.
All 7 of them could be there. In fact.
Yes.
That's not contradiction. What is the contradiction we are asking? Let him first answer that. First of all, in the judgment, there is no reference of contradiction.
There is no
The
reference of
learned judge says it's
contradiction.
vague, and the state has not preferred any appeal against that.
As far as these 2 persons are concerned, enough materials. Only issue is that why others were left out.
So conversely, he is arguing that there are materials to convict all, but since others have been let out, let us out. You have to give an answer to that. You have to say yes, or you have to explain why you have not preferred an appeal. We would want an affidavit from the State Home Secretary. Or otherwise, is it that you are selectively preferring appeal against acquittal? What criteria you are adopting?
That has
What
to be
criteria
again.
you are adopting? You have to tell us.
But the argument of my learned friend that since these have gone out, this will also go. That will not be that is not the the law laid down by the
that's the
Honorable
judgment he'll cite.
No, judgment is like on the same materials. If some people are left out,
Correct.
the same parity.
Let's forget everything. The only witness here is PW2. He's an injured eyewitness. She has implicated all of them. Somewhere she has named 3, somewhere she has named others. But she has implicated all of them. 149 comes in straight away here. Right?
Yes.
So therefore, there are incriminating materials against all the accused persons, all 6 of them, which have remained unimpeached. Despite that, 2 have been convicted, 4 have been acquitted. That judgment comes in is to his rescue. We have to give an answer legally. So then the state has to say, what was the criteria on which a decision was taken not to refer an appeal
Convicted.
against?
Uh,
Was it arbitrary? Was there any reasonable consideration? Or if not, then how, on what basis other appeals against acquittal are filed?
mm.
There are appeal against acquittal filed by the
Yes,
state.
yes.
On what basis you file?
It
There is
happened in
some
many judgments I've seen.
Private interest of somebody.
Mm.
What is the criteria followed?
No,
We would
that-
like to know that here. Because we are ultimately protecting the interest of the society,
Yes, of
which is the responsibility of the state also. So you have to tell us.
Mm. In her 164, Lordship can see, let me examine the judgment and everything. Lordship will give me some time. If I can at all make out some difference between these people and the rest too. And in spite of he being absconding, judgment is passed. Whether it will affect the other also, that will also have to be seen. Because it is not a case where in the beginning the case is filed. It is at the last stage.
Home Secretary will have to explain to us.
Lordship.
This matter is not going to come to an end very soon.
Mm.
Mr. Ahmed, you also have to be prepared for that.
Even in fact, when I moved the bail application, your lordship says that if this case comes for hearing in my court, there will be some difficulty on the part of the estate and luckily escaped before your lordship
I don't remember, but
because of this point.
what is all this happening? And we're surprised, grade 1 judicial officer writing a judgment in this manner.
Lordship will just see once 164 statement at page 111. There she in fact initially had implicated only these two. Later on, of course, she said about others also. 111.
Yes.
She initially said later, around so and so, when Gyasuddin was uprooting fatty sapling in the field, all of a sudden Motley pierced a spear through Gyasuddin's abdomen. The spear exited through his abdomen. At that time, Masan, who was with Motley, assaulted him too with her hoe. Noor Muhammad assaulted him. These again comes with her dagger. Jiabur and so assaulted him with dao, causing his death. We cannot separate these two with the others.
So she has implicated all of them.
All of them in 164 also.
And she has remained firm in her deposition also. So the question is, there is testimony of an injured eyewitness which has remained unshaken. And this learned judge says there is vagueness and the state accepts this acquittal.
He could
And
have gone into
absconding-
contradiction and all, but
Absconding accused is convicted. Police does nothing to apprehend him. We would like to write a good judgment and let it out in the public domain. So now, who will not do?
Yes, yes.
7 days time you have to come up with answers.
Yes, yes.
We don't get satisfactory answers, we are asking all of them to come to the court. You better tell them. Better inform the Home Secretary and the SP. Right now, we will not write anything else. But
Why in some cases they will do this and in some cases they will file.
what mechanism is
What
followed?
mechanism they, even I'm not aware what mechanism they follow. Perhaps whatever PP writes from the respective district courts, they file it.
That is their problem. If they are doing it in an arbitrary manner, then let them admit that they are not.
I'll tell Mr. Makhon also to be here. He might have some answers.
We'll fix it next Tuesday.
Lordship. This happens in many cases I have seen where there are materials, they don't file appeal, and where there are no materials at all, they'll come. Maybe they are following something, I have to ask them.
But they means now you are the face of the state. You have to say we don't
We, yes.
say that. You are still part of the state.
Mm.
When you cease to be, it's a different thing. Right now, you are part of the state. So you better ask your officials. If you don't get convincing answers, then we will have no option but to call them. Them personally appear.
People suffers. No. Okay.
Take down heard Mr. A. Ahmed, learned counsel appearing for the appellant. Also heard Ms. S. Jahan, learned APP Assam appearing for the state. In this case, there were, a trial was conducted against as many as six accused persons. Namely, in page 5, you will get the names, 1 to 6, page 5. I put a flag. During trial, the accused number 1, Muhammad Abdul Matlib, went absconding. Full stop. Notwithstanding the same, it appears that by the impugned judgment, notwithstanding the same, by the impugned judgment and order dated 5/8/2019, passed in connection with, passed by the learned additional district and sessions judge, Hojai, in connection with sessions case number 80 bracket N capital N bracket close public 210, convicted the absconding accused Muhammad Abdul Matlib and the present appellant stroke accused number 6 Muhammad Masan Mia, while acquitting the 4 other accused persons. Full stop. On a careful reading of the materials on record, we find that there were clear and clinching evidence available so as to convict the 4 accused persons who were acquitted. Full stop. Notwithstanding the same, without furnishing proper justification, the learned the trial court appears to have acquitted these 4 accused persons. And surprisingly, the state has chosen not to prefer any appeal against the judgment and order of acquittal. Full stop. Based on the same evidence, 2 other accused persons, as named above, had been convicted. Full stop. On a pointed query made by this court, the learned APP could not convince us with an answer as to how trial would have been proceeded and an absconding accused would have been convicted even after splitting the records and separating the case with regard to the said accused, namely Muhammad Abdul Matlib. Full stop. Not only that, the learned APP could not give us any convincing, any satisfactory answer as to what litigation policy is preferred by the state while considering as to in which cases appeal against judgment and acquittal is required to be filed. Full stop. The issue assumes serious proportion in our opinion, considering the fact that judgment and orders of this nature, whereby accused persons are acquitted by ignoring cogent evidence available on record, impinges on the interest of the society at large, and to that extent, the state would be answerable. Full stop. On the request of Ms. Jahan, this appeal is directed to be listed again on 17/12/2024 as fixed part-heard matter, so as to enable her to obtain necessary instruction from the concerned officials and place it before the court. Full stop. We will have to look into this matter. It's not about just a single accused person here and there. Matter is serious and nobody is looking into these things. You better, a copy of this order be furnished to Mrs. Jahan, learned APP Assam. You better write to your concerned officials and ask for it.
Yes.
Otherwise, we'll ask them to appear and give us.
Sagarika was here.
in 11. Maybe she thought this matter will, all right, we'll adjourn these cases.
Lordship.
This can go after vacation. 11, 12, 13, none appears for the appellant.
12 I am appearing. I'm 12. Here in this case also in one interesting issue is there, Lordship, that the entire trial was conducted in absence of PP, Lordship.
In absence of,
PP, public prosecutor.
who is conducted the trial? PP is the one to,
Yes, that is the case. That the trial started and concluded without, in absence of
say,
PP.
11 after vacation, 13 after vacation.
There are
12,
similar
12
cases.
also after vacation, then we'll have it.
Very fixed date maybe.
You say which date you want? 12 on the request of
Tomorrow, the same issue is there on board. I mean, without PP, the trial is conducted. Tomorrow, few hearing matters are there on the same issue.
On 22nd January.
22nd January 2020.
Obliged.
Yes, anybody else? Yes.
May I please your lordship? Lordship, item number 13. Kindly fix on Thursday, lordship.
Why? Immediately on reopening. Immediately on reopening of, make it second week of January 2020. All right.
Just 2 minutes.
It will go after vacation. The court will rise at 3:30 today. Because there is some, also-
Item number 2, it can be on 7th of January. 2 and 3.
all right. 7th of January, 2 and 3,
Yes, 2 and 3.
as requested by parties. What about your matter?
Mr. Nayak is here. Only clarification, your lordships, lordship will remember, there was an advertisement for filling up of sanction post. And I,
6th of January. That's the only question here because I have to rise early because of.
6th of January.
Yes. What is that matter here? That
Lordships wanted only one clarification. This is with regard to compassionate family pension. Lordship wanted only one clarification because they raised the objection that my husband was not a government servant. Now Lordship wanted to know whether the government servant has been defined somewhere. In the Assam Service Disciplinary Appeal Rules, Milord, the government servant has been defined. I have got the copy and it includes me, Milord.
let us see.
Yes. Down below. And my appointment was definition.
So nothing else is required to be argued, is it?
Milord, I'll place the judgment, Milord.
No,
Otherwise,
if you want to argue, then otherwise we'll close it today then for judgment. 15-20 minutes, both of you can't argue. I have to rise.
Lord,
Because-
6th of.
If you don't want to argue, then you can give a written argument and I can close the matter.
No, we'll argue, Milord. I'll persuade you, Lord.
Because if you argue, then I have to start from the beginning. I need
Fine,
to
my lord, fine.
recapitulate the
6th of
facts.
January. Yes,
Huh?
6th.
Lordship, may kindly make it the 7th, Lordship. 6th is a Monday, Lordship. On 7th of
7th?
Tuesday, it will be.
I think this issue has not been decided in any case, is it?
No,
No,
Lordship.
Milord.
So there will be need to write a
But,
judgment.
Yes.
So Lordship, 2-3 judgments I have, Lordship. There it has been explained. What should be the nature of that 1 year, qualifying period, Lord?
I know the
Why
judgment.
don't both of you make a small written argument? And
Yes,
on the next date when you argue, we'll close it.
Well, the
On
judgment relied on my friend was totally in a different footing. In those cases, the person was not regularized. The entire thing changes once the person is regularized or given a regular pay scale. I can appreciate a situation wherein he was continuously in ad hoc. He was not granted pension. That fine, my lord. Supreme Court is absolutely clear because he placed those judgments. I have seen those judgments.
Lordship will go through those judgments, Lord.
So
One
it will
sec.
require some application of mine.
Yes, sixth, seventh.
Because otherwise it will clear, quite open the floodgate, Lordship. There are
Floodgate.
so many similar situations.
Argument state will always come,
Lord,
but
state
point is what is right has to be done.
Yes,
is the
Lordship-
correct
Lordship-
position?
Lordship is just in the definition, Lordship. Lordship will clearly decide whether he was, that period of
That's
fixed
what,
pay
that's what I'm saying.
can be termed as a civil post.
Court has to interpret and decide.
Lordship.
That decision will be on the basis of law, not whether it opens floodgate or closes. That can be our
Yes.
concern. But it will require a little
yes,
application.
yes, yes. my lord.
Seventh. Fixed parted matter.
Yes.
Hopefully we'll get a full day's hearing on full day on
My,
7th.
Yes.
yes, yes,
Some tied up matters.
my.